just to... Very welcome to today's meeting of the Committee of Public Accounts. We have received apologies from Deputy Gagan. Before we proceed, I have a few housekeeping matters to go through as follows. Members are reminded of the provisions within Standing Order 226 that the Committee shall refrain from inquiring into the merits of a policy or policies of the Government or a Minister of the Government or the merits of the objectives of such policies. Members are also reminded of the long-standing parliamentary practice that they should not comment on, criticise or make charges against a person outside the Houses or an official either by name or in such a way as to make him or her identifiable. I would also like to remind members of the constitutional requirements that in order to participate in public meetings, members must be physically present within the confines of the Leinster House complex. Members of the committee attending remotely must do so from within the precincts of Leinster House. The agenda for today is to discuss the minutes, accounts and statements, correspondence and upcoming meetings. We will then suspend and begin the engagement with officials from Inland Fisheries Ireland and the Department of Climate, Energy and the Environment. The minutes of the meeting of the 19th of March 2026 were agreed by the committee and these will be published on the committee's website. The accounts and financial statements. There are 8 sets of accounts and financial statements laid between the 16th and the 25th of March 2026, which are due to be considered today. And we're joined by the Controller and Auditor General, Mr. Seamus McCarthy, who is a permanent witness to the committee. I'll ask the Controller and Auditor General now to address these before opening the floor up to members.
Just there was one issue from last week, a query about the financial statements of CHI in relation to the contribution of €30,000 towards a Christmas party from a concession holder. The Deputy McAuliffe had a query about how it was banked and accounted for. It was actually lodged to CHI's general bank account. It was accounted for as deferred income at the end of 2022 and 2023, and when this was queried, the board of CHI concluded it should be returned to the concession holder. So just to complete that from last week. The accounts for this week, first there's the account of the public trustee. This is a 2025 account. They're beginning to come through now. That received a clear audit opinion. Number 2 is the financial statements of Royal Irish Academy of Music for 2024. They received a clear audit opinion. Number 3, the financial statements of the Food Safety Promotion Board, also called Safe Food. This is one of the North-South bodies which I audit jointly with the Auditor General of Northern Ireland. These are the financial statements for 2024. They received a clear audit opinion. However, information about senior management remuneration and pension entitlements, which was presented with the financial statements, is not fully compliant with the reporting obligations on North-South bodies. The obligations were increased with effect from 2024, and the information, while there is considerable information given, it isn't fully compliant, and I'm obliged to draw that to your attention. Item number 4, the financial statements of Atlantic Technological University for 2023 and 2024 received a clear audit opinion. However, I drew attention to the writing off of €427,000 of capital expenditure in relation to professional fees incurred for a proposed project to construct a new student building that did not proceed. Number 5 is the land bond winding up account for 2025. That received a clear audit opinion. That's effectively a dormant account. Number 6 is the account of the Local Loans Fund, again a dormant account, and these relate to 2025. That received a clear audit opinion. Number 7, the financial statements of the Health Research Board for 2024. These received a qualified opinion. The accounts give a true and fair view, except that they account for the costs of retirement benefit entitlements only as they become payable. That's standard for many health bodies at the direction of the Minister for Health. However, I drew attention to a disclosure in the statement on internal financial control in relation to the proceeds of 3.4 million euros from the sale of a property in May 2023, which were liable for surrender to the Exchequer in line with standard public finance procedures. In July 2024, the board sought formal sanction to retain and use the proceeds for a specific project. A decision was still awaited from the Department of Public Expenditure at the time the financial statements were certified, which was just before Christmas of 2025. The funds were lodged in a non-interest-bearing current account in July 2023 and were only transferred to a low-interest demand deposit account in November 2025. I understand that subsequently the department did provide sanction for the Health Research Board to retain the funding. Number 8, we have the financial statements of Inland Fisheries Ireland for 2024. They received a clear audit opinion. However, I drew attention to 4 matters, and I'll be elaborating on those in more detail in the opening comments. But just briefly, I referred to the terms under which the former CEO was remunerated in 2024, but also in relation to 2025. I drew attention to a lack of control of receipts in respect of a salmon research programme operated by the Marine Institute and how that was dealt with by IFI. I also refer again to the costs in relation to a collision that occurred in 2021 involving an uninsured vehicle. There is an ongoing WRC case related to that matter, and I drew attention to a material level of non-compliant procurement.
Thanks for that, CNAG. Deputy Neville wanted to come in there.
Just a couple of questions. Just the Atlantic Tech University, the 427,000 of write-off, obviously that's professional fees. Was there a specific plan there, or did it relate to one item?
It was...
Like 427,000 is a huge amount of professional fees for something that didn't go ahead.
It's a lot in relation to something that didn't proceed, but in the context of a multi-million building, that would certainly be the order, and significantly more in relation to professional fees,
I know
design
that,
fees
but
and
for
so
it not
on.
to go ahead then, you want to be sure before you're spending 427,000 this month.
That's the reason I was drawing attention to it.
So $500,000 written off and nothing to show. So was one, do we know where it is?
In Athlone.
It was in that location, that specific location. Was it?
Sorry, it's not
See, it's
Athlone. This is Atlantic.
It's a multi-location
yeah,
place.
sorry, this is Atlantic.
It's Galway.
No, I can't remember offhand where the building is, or where the intended building was to be.
That's fine. And then the Health Research Board, I just had a question. Like, I suppose the issue there is obviously, look, I suppose with the 3 million, I can understand that they might want to use it, they request to use it, but it was just sitting there, and I suppose the key issue there is that it was just sitting for a couple of years and nobody was doing anything, while costs might have been increasing. That's, you know, it was basically just a waste of capital.
Yeah, and
obviously the interest, lack of it, not being in an interest-bearing account, obviously. So at a time when interest rates are probably slightly higher.
Correct. Okay. And it's clear under standard public finance procedures that the body was not entitled to retain the funding unless it had a sanction. Now, in fairness to them, they requested it, but there was a considerable delay. And in the meantime, it was sitting in a non-interest-bearing account.
Okay, Deputy Bennett.
Yeah, I just want to ask, are the Health Research Board, are they coming before us at any stage in the pack? Are they on our list? No, could we ask that they would come in for into the PAC? It's just like 3.4 million. If the department said this was okay, that they would just leave 3.4 million sitting in an account for over 2 years, maybe we should have the department that sanctioned this in here also. Like 3.4 million is a lot of money to be sitting in an account and nobody is being held accountable for it. So I would ask that the Health Research Board are called in here, and maybe the Secretary General of that department, to see why this money was sanctioned just to sit in an account. So many people are looking.
Yeah, the sanction was required from the Department of Public Expenditure. So maybe the best avenue would be to write to the department and ask what was the reason for the delay.
Yeah, okay. Just 3.4 million, you know, a lot of people, that could have been used instead of sitting in an account.
Okay,
So I would-
we can do that as a
Thank you.
first course of action, right to the department. Any other members wish to?
Sorry, I just go back to the Advanced Technological University. Just would it be normal could they be asked, you know, maybe, I don't know, maybe it wouldn't be its own pack necessarily, but maybe part of another group, if there's any other universities or any other colleges that we might feel.
Yeah.
You know, like, because that's,
Yeah.
you know, it's good to explain that and we understand it, but then, as I said, I know it might be part of a broader day we might have.
It is something that has happened with other third level institutions, and I've also drawn attention to those. I can recall at least two where there were similar write-offs.
Yeah, maybe we collate
Well,
a few groups.
think, yeah, in the first instance, I propose that we write to the university in question, also write to the department for further education.
Yeah,
to try get you know, because I'm sure there was a comprehensive plan put together around this.
Yeah.
We need to know why it didn't proceed. Was it a lack of capital funding, or was there some other issues there? So I think to try
maybe
get
set out what the 427 encapsulated.
breakdown.
Yeah.
Just
I think in the circumstances, like these projects tend to have a long lead time. And I think one of the things that happened with the construction price inflation around 2021, 2022 was that projects which had been within a capital envelope suddenly became unaffordable. Okay. And I think that was what triggered the writing off of these kinds of funds.
we'll write to them and get a full Deputy McGrath.
Thanks, Chair. I just want to support Deputy Neville on that. I think it's a huge sum of money, and just to question the management of the project from the very early stages and the decision to then not to proceed. What were the key reasons why? And I think we do need to investigate that. So I support the suggestion we write initially, but I think potentially we need to keep in reserve the option of having a session in relation to that. Can I just ask the CNAG in relation to the CHI and the 30,000 in relation to the Christmas party? Do we know how long that money was in the possession of CHI? It was ultimately returned when the board became,
It was returned
when the board became aware of it. But do we know how long that process took?
It was returned, I think, in 2025.
2025,
Yeah.
So, and it was received in 2022. So
2022, or perhaps very early in 23. I don't have the exact dates.
it was in the 2022.
I think it was in 20.
It was in the 2022 council.
It was included. It might have come in just in the beginning of January, but I take it that it was at the end of 2022.
Okay.
But I don't have the exact date.
And this was discussed in our private session, and there was a proposal from Deputy Farley that we do write to CHI in advance of our engagement with them now in a number of weeks, because the vendor was named yesterday at the Health Committee, and I suppose there's serious questions there as to, you know, what procurement process, if any, had been ongoing at the time. So we need a full line of sight, and we are going to, we had agreed to write out to CHI last week, looking for clarity around the vendor, name of the vendor, etc. Things have progressed. We now know that name. So we will be corresponding with CHI, seeking further information on that and full disclosure in advance of our engagement with CHI in the coming weeks.
Chair, I'm not aware that there was a live procurement at the time. To make that statement.
Okay. So unless there's any other members there, do members agree to note the listing of accounts and financial statements?
Yep.
Agreed. Okay, moving on to correspondence now. There's a number of pieces of correspondence. I'm going to defer most of those bar one that has been flagged. So we'll defer them until our next meeting. The one piece of correspondence that has been flagged by Deputy Farley and myself is item R 2026-0152, and that's correspondence excuse me, received from the chairperson of the OPW in response to the committee's request for further information. So, Deputy Farley, you had flagged this.
Thanks, Chair. I'm just very briefly seeing the correspondence come in from the OPW this week with regards to Hammond Lane, that the tendering process is currently live and the OPW expect construction to begin in 2027, not to be completed until 2029. I think that's unfortunate. I think given that we've been speaking about this project for decades now, with that in mind and with a previous request that we've made regarding the Metrolink project, I'm proposing that the committee requests that the OPW and anybody in charge and responsible for the delivery of this at construction stage would provide the committee with quarterly updates about this project, given the sizable nature and importance of such a project. There's many questions to answer with regards to how we've gotten to this point, but looking ahead now, I think it'd be really important that we do receive those kind of periodic updates with regards to the project delivery.
Okay, thanks for that. The other issue I just wanted to touch on in relation to the correspondence from the OPW, they gave us an update following our engagement with them here around the vacant properties within the Phoenix Park, and also the rent which is charged to, I suppose, tenants availing of properties within their portfolio. And there was a lot of concern there in terms of that. They say they are carrying out a review of the rents charged to tenants utilising the properties, which I think is welcome and comes on foot of our engagement and concerns here at committee. Now, what is of concern for me certainly is the former Garda Commissioner's property within the Phoenix Park, which we now know is lying vacant after considerable amounts of money spent doing that property up. It's now vacant for over 6 months at this stage. The OPW tell us that review process looking at the rents and the utilisation of vacant properties is going to be concluded later this year. So that means that property is going to be vacant for at least another 6 months, along with, I think, 11 or 10 or 11 other properties within the Phoenix Park. That to me is concerning and totally unacceptable. So I think we need to communicate back with the OPW, firstly to keep us fully informed in relation to the review of rents being charged, and the process in which is going to be utilised going forward, but also the properties in the Phoenix Park need to be brought back into use, particularly the former Commissioner's property, which is it's done up, it's ready to be inhabited immediately, and that needs to be brought forward and addressed. So again, deep concerns that that is potentially going to be left vacant for another 6 months, in my mind, is totally unacceptable. So just to get an update and to be continuously updated from the OPW in relation to that. So we'll move on just to the next item there. We'll defer the other pieces of correspondence, move on to the work programme. So on the 16th of April, the committee is due to engage with the Department of Education and Youth with representatives from DEPR to resume discussions on the department's appropriation account 2024, Vote 26 Appropriation Account 2024 and the CNAG's report on the accounts of the Public Services 2023, Chapter 7, Protecting the State's Investment in the Schools Estate. Moving on to Aingan O'Ella, are there any other items which members wish to raise? Deputy Bennett.
Thank you, at our meeting on the 26th of February, I asked DEPR and the Department of Education where they had found the 19 million to accommodate the SNAs that were required in all schools. I'm still waiting on a response back from that. I asked at that time where the allocation had come from and to ensure that there would be no cuts to any other services. So I would ask today that a letter would be sent again to DEPR and the Department of Education to ask them that question, please.
Yep, that's agreed. Deputy Kenny. Just Deputy Kenny, and then yourself, Deputy Byrne.
I'm happy for Deputy Byrne to come in if it's on the same topic. Mine is separate.
Yeah, just in a follow-up on that, I also requested all of the correspondence between both entities in relation to where the 90 million was coming from. And I asked for the minutes of the meetings where it was discussed and any correspondence relating to it. We haven't received that either, so if that could be followed up on as well, please.
Yep, that's agreed. Deputy Kenny?
Yeah, I suppose just to highlight again, as I did in private session, that the committee have agreed, and to thank my colleagues about writing back to the Garda Commissioner in relation to a question I put to the former Garda Commissioner, Drew Harris, in relation to a Chief Superintendent and his wife who are based in Dublin, staying in a 5-star Dublin hotel during the visit of former US President Joe Biden. And I'm glad to say that we'll be asking when and who the investigating officers from the Anti-Corruption Unit met in relation to their investigation, and if official records were kept at these meetings, to ask for the names, the length of stays, the official base of all Gardaí who stayed in the Dublin hotel during the visit, and who paid for it, or was it reimbursed on Garda Síochána, and to provide evidence of the financial account that paid for these hotel stays and documentary evidence of such. I think it's important that we follow up this case. I would be cognizant of the fact that public funds were used for these hotel stays, and I think it's important that full clarification is given to the committee on what actual investigation or how thorough the investigation was by the Anti-Corruption Unit.
Okay, that was agreed by members. So unless there's any other items under AOB? No. So that concludes session 2. So we will now suspend the meeting for 5 minutes. begin in public session. This morning we will engage with Inland Fisheries Ireland to examine the financial statements of 2024, the financial statements of 2023 and the Controller and Auditor General Special Report 118, Governance, Internal Control and Value for Money issues within Inland Fisheries Ireland. On behalf of the committee, I would like to welcome officials from Inland Fisheries Ireland, Professor Tom Collins, the Chair of the IFI Board, Mr Barry Fox, Deputy Chief Executive Officer, Ms Suzanne Campion, Head of Finance, Corporate Services, and Mr John McPhillips, Contract HR Lead. We are also joined by officials from within the Department of Climate, Energy and the Environment who are attending in a representative capacity. Ms Una Buckley, who is the Secretary-General, Ms Martina Hennessy, Assistant Secretary-General, Mr Gary Martin, Principal Officer, and Mr Jim Whelan, the Principal Officer. And finally, we are joined by officials from the Office of the Controller and Auditor General, including the Controller and Auditor General, Mr Seamus McCarthy, who is a permanent witness to the committee, and Mr Gina O'Mahony, the Deputy Director of Audit. You're all very welcome before us this morning. Before we begin, I wish to explain some limitations to parliamentary privilege and the practice of the Houses as regards reference you may make to other persons in your evidence. The evidence of witnesses physically present or who give evidence from within the parliamentary precedents is protected pursuant to both the Constitution and statute by absolute privilege. This means that you have an absolute defence against any defamation action for anything you say at the meeting. However, you are expected not to abuse this privilege, and it is my duty as Cathaoirleach to ensure that this privilege is not abused. Therefore, if your statements are potentially defamatory in relation to an identifiable person or entity, you will be directed to discontinue your remarks, and it is imperative that you comply with any such direction. Witnesses are also reminded of the long-standing parliamentary practice that you should not criticise or make charges against any person or entity by name or in such a way as to make him or it identifiable or otherwise engage in speech that might be regarded as damaging to the good name of the person or the entity. And before we move on to the opening statements, I just to say that I think this is an unprecedented meeting here this morning to have Inland Fisheries back in before the committee so soon after having you in December. It's unprecedented in my view, and it's born out of deep frustration at our previous engagements, where I think the engagement was less than helpful. I think there was a deep level of frustration amongst all members of the committee by the level of engagement, the level of openness or lack of from IFI at that particular meeting. So I would ask that our witnesses are helpful today, that if anyone feels they have any relevant information, not to sit back and hold that information till the tail end of the meeting. So please be open, be frank, and be forthcoming with any information that you believe would be helpful for us in our deliberations and scrutiny of the financial accounts and affairs within Inland Fisheries Ireland. So I now call on the Controller and Auditor General, Mr Seamus McCarthy, for his opening statement.
As members are aware, Inland Fisheries Ireland is the primary state agency with statutory responsibility for the management, protection and conservation of Ireland's inland fisheries and sea angling resources. These literally priceless resources include a huge network of natural waterways, important ecosystems and heritage artefacts, and diverse fish stocks. Inland Fisheries Ireland was established under the Inland Fisheries Act 2010, amalgamating the former Central Fisheries Board and 7 former regional fisheries boards. Amalgamating the boards was intended to achieve a cohesive national approach to the work and to achieve greater effectiveness and efficiency. The board of a state body is responsible for ensuring that effective systems of internal control are put in place and implemented. These include financial, operational and compliance controls and the system for risk management. The special report was undertaken to review a number of concerns regarding Inland Fisheries Ireland's governance and the adequacy of its internal control systems. As the issues reported upon have been discussed previously by this committee, I don't intend to itemise them again today. I might point out that the nature, volume and complexity of the concerns raised about IFI's governance and systems of control was such that they could not be adequately dealt with in the course of an annual financial audit. My aim in issuing the special report was to try to clarify matters and to eliminate certain misunderstandings that had arisen. As it happens, some of the matters reported on have continued to evolve. My office has encouraged IFI to be as transparent as possible in their financial reporting about those matters and how they are being dealt with. One of the consequences of the governance issues that emerged is that for a number of years, financial reporting by Inland Fisheries Ireland has not been as timely as it should be. I can report to the committee that I certified the 2024 financial statements on the 24th of March 2026. That's just 2 days ago. I intend, with the cooperation of IFI's management and board, that the audit of the 2025 financial statements will be completed before the end of this year, and that IFI's financial reporting will remain as timely as possible in the future. To summarise briefly the financial results for 2024, IFI's income amounted to €42.7 million. Just under 90% of the income comes from state funding sources. Much of the remaining income relates to fee income for permits and licences, fishery rates, fines and forfeitures, and project income. IFI's expenditure amounted to €41.9 million. More than 70% of the expenditure, or €30.7 million, was in respect of remuneration and other pay costs. The balance was spent on non-pay field operations and administration. I issued a clear audit opinion in relation to the 2024 financial statements. However, I drew attention in my audit report to a number of matters. First, Note 6F to the financial statements discloses salary payments totalling €155,000 made in 2024 to the former Chief Executive Officer. He was on leave from March 2024 until his employment with IFI ceased in early June 2025. Salary payments totalling €77,000 were made in respect of the period January 2025 to June 2025. In addition, the former Chief Executive Officer received payments totalling €145,000 in lieu of the remainder of his contract term to November 2025 and for accrued leave untaken. A Workplace Relations Commission case subsequently taken by the former Chief Executive Officer against Inland Fisheries Ireland is ongoing. Second, I drew attention to a disclosure in the Statement on Internal Control about how income from a salmon tag bounty scheme was handled within IFI. The scheme was operated by the Marine Institute as part of a long-term salmon stock research programme. Over the period 2010 to 2023, the Marine Institute made bounty payments totalling €41,500 in respect of IFI staff participation in recovery of the tags. Bounty payments totalling €13,500 were lodged to bank accounts within the ownership of IFI and were recognised as income in the financial statements for the period 2010 to 2014. However, from 2010 to 2023, further bounty payments totalling €28,000 were made to individual staff members and into bank accounts not controlled by IFI. Inland Fisheries Ireland investigated this matter following a protected disclosure and has reinforced its controls around contract income. Third, Inland Fisheries Ireland discloses that it has incurred costs of €205,000 to date in respect of a collision that occurred in 2021 involving one of 15 vehicles in its fleet that were uninsured for a period due to an administrative oversight. There is also an ongoing Workplace Relations Commission case related to this matter. Fourth, non-compliant procurement totalling €717,000 in 2024 was identified, relating to 9 suppliers. the manner in which IFI's contracts register operated did not identify a significant number of the non-compliant procurement contracts. Finally, members will recall that in March 2023, IFI discovered that formal delegated authority allowing its officers to initiate prosecutions was not in place. As a result, certain prosecution cases had to be discontinued. The Statement on Internal Control for 2024 discloses that IFI had incurred expenditure of almost €277,000 in respect of its own and defendants' legal costs in withdrawn cases, and that it is awaiting court rulings in respect of legal costs for 5 other cases. While it's regrettable to have to continue to report in this way, it is important that IFI bottoms out these governance and control issues and takes the necessary steps to avoid any reoccurrence. This will allow it to bring its primary focus back to the vital task of protecting, preserving and developing the invaluable waterways, fish stocks and ecology within its remit. I
will now ask the Chair of the Board to deliver the opening statement on behalf of Inland Fisheries Ireland. Professor Collins, as set out in the letter of invitation, you now have 5 minutes to make your opening statement.
Thank you, Chair. Good morning, everybody, and thank you for the opportunity of being here. You referenced, Chair, the meeting of the 4th of December. I looked at that meeting online. It was highly charged, and looking at it as an external person, it was very clear to me that this was damaging to the organisation, to its reputation, and to its credibility in the public domain. We have, of course, since that meeting, clarified some of the issues which I've also dealt with in my opening statement. There were a variety of misdirections and misapprehensions by members of the committee with regard to some of the questions that were being asked, particularly with regard to car insurance and with regard to an alleged review conducted by Minister Eamon Ryan. Just for the record, Minister Eamon Ryan did never commission a review on the matter that was being discussed. And also for the record, the matter of the uninsured vehicle was never an issue that was brought, that a summons was issued on with regard to insurance. A summons had been issued, but it was not with regard to insurance. I simply want to place that on the record. We accepted as a new board of IFI, we are in place since January of 2024. We accepted the special audit report that the CNAG has referred to. We accepted all the findings. We don't challenge them. We have set about attempting to deal with what is undoubtedly a very negative legacy. As I said, we are accepting all of the findings in the report. We are recognising that this board is tasked with a serious job of clean-up and of dealing with the backwash. It is difficult to escape your history, and history tends to catch up on us in all kinds of ways. And this history is still lapping around our ankles, if I can mix my metaphors. I do think, though, and I'm conscious that I have limited time, there are 3 things we now need to achieve as an organisation. We need to deal, as you've indicated, Chair, with any outstanding questions this committee has, and we will attempt to do that as well and as effectively as we can today. Secondly, I think we need to give an assurance that the systems are in place, which, as the CNAG has referred, to ensure that we're not back here again. And thirdly, I think it is important quickly to call attention to the role and purpose and effectiveness of the organisation. And I might be, because of the shortage of time, address a few very quick issues that people were concerned about. At this meeting on December the 4th, the delegation was asked about PDs. We have had 38 PDs into the organisation, that's protected disclosures, since 2022. Of that 38, 29 are anonymous. And the great majority of them were either not moved on to meet to the threshold, or were not considered to meet the threshold as a PD, or alternatively did not stand up when investigated. Of the 39 that were submitted, it appears that a minority of certainly less than 5 stood up to and were upheld in investigation. However, it does raise a question, and the committee members did raise it, about the culture of the organisation. It is important with regard to PDs to say that any one member can submit a multiple number of PDs. It is not in any way confined. There's no limit on what one can do. We are obviously trying to deal with anonymous PDs, which raise very serious resource challenges when we don't actually even know the source. However, we have appointed a subcommittee in the board for culture and people, and at the end of this month, the end of this year, we will launch a culture audit. I also want to say, when this board was appointed, we took on the task of meeting all of the staff in the field. We went around to all of the regions and met the staff there. In that regard, we found the staff who were generally, I think, very highly committed, very high level of expertise, and highly dedicated. So, anecdotally, I do not experience a culture issue in the organisation, but I do realise and accept that people might take a different view on this. We have, in terms of the reputation of the organisation, we are dealing with a WRC case, which the CNAG referenced, with regard to the former CEO. He has taken the cases in the public domain for unfair dismissals. I won't be able to deal with this today, and I really want to apologise for that now, because it is sub judice in the sense that we have sat for 3 days already in the WRC in the beginning of March, and we're looking at a further 4 days designated for the end of June and the first 3 days of July. And that is no guarantee that the case will finish then. I can give you an absolute undertaking, of course, that whatever the findings of the WRC emerge, we will provide them to the committee. But I do want to say that. With regard to the long-term issues and the role and effectiveness of the organisation, I think it is important to point out, as I do in my statement, we have 74,000 kilometres of waterways in Ireland. We have on top of that 300,000 acres of lakes. We have a coastline which, as far as I know, is roughly the same as that of France. Ireland has a massive job to protect its waterways. In a crude calculation, I've worked in the world of higher education all my life, where we talk about staff-student ratios all the time. The ratio of patrolling range per person in IFI is about 320 kilometres. It is 60 kilometres more than the distance between Dublin and Cork. Now, I say that simply to say that this presents an enormous challenge in terms of managing, obviously, prosecutions, managing pollution spills, responding to pollution spills. We had a tragic development in the Blackwater in August. We estimate ending up to 40,000 fish in the fish kill in the Blackwater. IFI was criticised by various people, and some people, with regard to its response rate, with regard in particular to the failure to identify the source of the pollution. It is a matter of great regret that we didn't. We did commission at the behest of Minister Dooley. He asked us to get an independent review of our handling of that particular episode. That was done and concluded on the 30th of January of this year. The independent review was carried out by the Joint Research Committee, our Council of the European Union. It concluded, by and large, that IFI had managed the investigation competently and comprehensively. I will say it also drew attention to the fact that we did not communicate it very well, and it called attention to the need in particular for an emergency protocol, interagency protocol, which we are now leading out on developing and hope to have completed in the coming weeks. It also drew attention, and this is where I move to my final point, with your indulgence, Chair. It also drew attention to the cumulative pressure of rivers like the Blackwater. And in that regard, this pressure arises from multiple sources, but it's reasonable to assume, I think, that any river in Ireland, which is in an area of intense agriculture and an area of intense industrial development, is going to be under severe pressure. Questions were raised at this meeting regarding the Boyne on December the 4th. I've lived on the Boyne for 30 years. The Boyne, I don't want to overstate things here, but it is a sacred river in Ireland. It is named for the goddess Boan. It has sustained life in Ireland for 5,000 years. And in the last 50, it has practically died as a river. The work of peat harvesting, of drainage, of intensive agriculture, and a variety of other players have managed to reduce, in combination, the returning salmon stock to the Boyne, which, as you know, gave us the salmon of knowledge, to 10% of its conservation threshold. I do feel that modern Ireland has become desensitized, or is increasingly desensitized, to the aesthetic ethic of environmental protection. And from people littering streets to polluting the Blackwater or other rivers is simply a linear progression, in my view. So I will conclude, Chair, by essentially saying regulation of the environment, and you have the Secretary General here from the department. I don't want to speak for the department here. The regulation of the environment as to achieve water goals, carbon and climate goals, is going to be a challenging undertaking. There are pushback from multiple interests and multiple forces in the country, as there are everywhere. We believe we are part of an important part of an ecosystem of regulatory bodies that are saving and protecting and doing their best to protect the environment from the kinds of onslaught that the Blackwater drew our attention to. I do think that the current discomfiture of IFI is probably some comfort to those interests. And that, in a sense, places an even greater responsibility on us to solve the governance problems that you alluded to, Chair, and that the Secretary, that the CNAG alluded to. And while the events under scrutiny today predate the appointment of the current board in most instances, though I accept not all, because you now have, of course, the accounts for 2024 presented to the Dáil. We completely understand, however, that as a board, we will be judging our effectiveness in dealing with the clean-up and the backwash from these historical events. We recognise the absolute imperative of satisfying all of our accountability responsibilities in this regard, including our reporting to this committee, such that we regain public confidence in our capacity to deliver on the crucial national objectives that we have been entrusted with. Thank you, Chair.
I will now ask the Secretary-General to make her opening statement on behalf of the Department of Climate, Energy and the Environment.
Thank you very much, Chair, and I'd like to thank the committee for the opportunity to engage with you today on these important matters. In addition to the officials already referenced, I'm also joined here today by Ms Catherine McGinty, who is the Principal Officer in Inland Fisheries Section, working to Martina Hennessy, who has responsibility for the Inland Fisheries function in the Department. Mr Whelan here is my Head of Finance, and Mr Gary Martin is the Head of Internal Governance in the Department. Inland Fisheries Ireland plays a critical statutory role in protecting and managing the state's inland fisheries resource, as you've heard so eloquently from the Chair of the Board. It is a non-commercial body established by statute in 2010 and as such is primarily founded by the Exchequer, with some 35 million provided annually by the Department, the IFI. I'm sorry if my phone is ringing. It's my Minister who obviously has forgotten I'm the PAC this morning. Apologies for that. As is the case with all Aegis bodies, it's important that the organisation operates to the highest standards of governance, accountability and transparency. The Department takes its responsibilities for the state bodies under its Aegis very seriously, and strong structures are in place to ensure a consistent and robust approach is adopted in this regard. The issues that arose in IFI and which have led to the report under discussion today were very serious and unacceptable and were treated as such by the Department. These matters have been very damaging for the agency, and it has a significant task ahead of it to restore and to maintain public confidence. Transparency and ongoing Oireachtas scrutiny will be an important element of this process. It is important to note the significant work that has been undertaken since 2023 to address these issues. A comprehensive programme of reform was developed by IFI, informed by an independent review carried out by EY at the Department's insistence to address the issues identified. It is encouraging that all recommendations arising from the EY review have now been implemented, including measures to strengthen board oversight, clarify roles and responsibilities, and improve governance and reporting arrangements. I acknowledge and commend the work of the Chair and the board members since their appointment in January 2024 to strengthen and embed governance standards and procedures within the organisation. And it is to be acknowledged that it is brave of people to take over as board members of an organisation, in such public disarray. So they are to be commended for that. The Department remains actively engaged with IFI and its board to ensure that these changes are sustained. The EY review also included a number of recommendations for the Department, all of which have also been implemented. These focused on strengthening oversight and engagement arrangements, clarifying roles and responsibilities, and enhancing reporting and information flows between the Department and IFI. And in this context, it's important to note that the Department's role is one of oversight, support and escalation. This role is discharged through formal governance mechanisms, including governance agreements and regular governance engagements. These mechanisms provide structured monitoring of performance, financial management and compliance, while respecting the board's independence and avoiding involvement in day-to-day operational matters. In recognition that corporate governance is constantly evolving, my own department has recently established a dedicated corporate governance unit in respect of our non-commercial agencies. We previously had one for the commercial agencies. And this unit supports a more coordinated, consistent and structured approach to governance and builds internal governance capability within the department itself to ensure that governance frameworks are applied in a more systematic way across all our agencies. The department is also progressing new legislation to support IFI in delivering on its statutory remit. Much of our inland fisheries legislation is dated and fragmented, which makes it complex for the IFI to enforce. Modernisation will help streamline this regulatory framework, provide stronger enforcement tools, and address pressures such as climate change, water quality and habitat degradation, all of which are essential to protecting our inland fisheries resource. As I mentioned to the Chair earlier, a number of the matters previously discussed by the committee relate to issues that are the subject of protected disclosures or relate to ongoing employment cases. And while some information may have entered the public domain, both the Department and indeed the IFI remain subject to the strict confidentiality obligations set out in the Protected Disclosures Act. And for that reason, I hope the committee will appreciate that there may be limits to the level of detail or indeed the replies that I can provide or commentary that can be made in relation to certain matters. To the very greatest of our ability, we will answer the questions posed to us by the members of the committee, but it has to be within those statutory constraints. And we look forward to assisting the committee members with any questions they may have today.
Thanks for that, Ms Buckley. And please note that we will suspend the meeting at about 12:30 for a 15-minute break and then resume there shortly afterwards. We'll now open the floor up to members, and the lead speaker today is Deputy Boland, who has 15 minutes, and all other members have 10 minutes after that. And if time permits, on conclusion of the first round of questions, and with the agreement with our witnesses, we'll open it up again for a second round of shorter supplementary questions. So, Deputy Boland.
You're all very welcome here today, and I want to firstly start off by thanking you for signing off the 2024 accounts in time for this meeting. We didn't think we would have them, so I really do appreciate the efforts that you have made in getting them to us yesterday. And I would also like to echo Ms Buckley's comments in relation to people stepping into directorship roles, particularly when organisations have a legacy or certainly a history of very tricky and complicated issues. So thank you for that. That's not to say that I'm not going to test you. And look, to be honest with you, the IFI has occupied far too much time of this committee. Your objective is to protect, manage and conserve Ireland's inland fisheries, and we want to see that. We want to see you doing that, but we have to be assured that corporate governance is in order, that all of the issues have been resolved, and as best as we can, that we can draw a line under matters here today. So I'm going to turn to the 2024 accounts. And I do appreciate matters are obviously before the WRC, so I will try and go through this gingerly. The 2024 accounts make reference to the CEO contract and his departure. Can you firstly confirm to me, was that CEO contract the template Department of Public Expenditure contract?
Yes.
For CEOs for non-commercial semi-states. The CEO was on leave, we have been informed, on leave for a period from March 24 to June 25. At any stage, was he paid full salary or half salary, or you might let me know what the payment looked like in terms of that period?
Yeah, I think I can respond to that and you'll have to bear with me. I am absolutely keeping one eye on the.
We'll go carefully.
The WRC
I appreciate that.
situation. But the answer is that for a period of that, he was on half pay. But for the greater part of it, he was on full pay.
And was there a legal basis for moving him to half pay?
There was legal advice. Oh, sorry. Yes, there was legal basis. It is part, to be frank, this is part of the specific complaint that has come in front of WRC. So we say there was.
So the template contract, did it contain a termination clause?
It contained a statement to the effect that, as head, I can't recall the exact wording, but yes, it did. It provided a mechanism for terminating the head of an agency, yeah.
On 3 months' notice in writing. That's the standard.
Yeah,
That's what's in the template at 6.1.
So there was a mechanism there, yeah.
Yeah. And so was the termination by mutual agreement?
Well, he has taken a case for unfair dismissals, so that should probably answer that question.
So the IFI served notice of termination on him?
Yes.
What date did the IFI serve notice of termination?
Off the top of my head, it was June of 2025.
Right. So it looks to us like the contract was terminated in June 2025. So was notice also served in June 2025? Or would it have been served 3 months before then?
No, it was served in, the notice was included in the payment. The notice.
So he was paid in
payment in lieu of notice.
For the 3 months.
Was included in the severance arrangement.
So that would have brought us up to October 2025 if we're paying 3
Yeah.
months in lieu.
Yeah.
And then there was an element of annual leave that was
Yes.
paid out. How much
Holiday
annual leave?
Yeah. Yeah.
Did annual leave
Yeah,
make up?
yeah. My recollections were 5 weeks there.
Okay, so there was a payment of 145,000, but in reality, those payments related to the 3 months payment in lieu of notice and all annual accrued
Yes,
holidays.
and there were also some leave brought forward, and it was calculated essentially, and I think it was stated at the last meeting, we as a board decided to pay out the contract with all our liabilities and draw a line under the matter.
Now, you weren't legally obliged to pay out a contract. That's not legally, you're not
No,
contractually
but
obliged.
I can say we were legally advised.
Okay,
Yeah,
that's
but-
different.
But no, we're not legally
No,
obliged.
and we need to be very
No, I
careful
accept
here.
it.
Yeah.
I totally accept there was provision in the act, in the contract to have acted differently. We chose not to.
And I suppose what I'm hearing, Professor Collins, is that it's almost coincidental that the contract was to expire in November, in that you paid the 3 months notice in lieu, plus accrued leave took you up to November.
No, we paid the contract out, and that included.
But you were legally
there were 5
obliged to pay
months.
3 months.
No, so that we're 100% clear, there were 5 months remaining on the contract when we terminated in June. The contract ended in November, end of November. We paid those 5 months in addition to any accrued leave or other.
But you would have been
Entitlements.
obliged to pay the 3 months anyway. You
Yeah,
had,
yeah,
You
absolutely,
had to
yeah.
give, you had to pay the
Yeah,
3
yeah,
months anyway.
Correct, yeah.
So when you say you paid out the contract, how much annual leave would have been on top of that 3 months?
5 weeks is my recollection.
So really you're saying you only paid an additional 3 weeks?
No, I think, because I want to be absolutely clear on this, his contract was extended until the 30th of November, is my recollection of that date, 2025. That, the salary payments for each of the months from June to the end of November were paid.
Yes, but you would have had to pay 3 months of those anyway.
We would have had, yes, there was a 3 months.
Plus you would-
Correct,
Yes.
so, sorry, yeah.
Sorry, 3
That
months.
is correct, yeah.
Plus 5 weeks.
Yes,
So essentially, we're saying there was only really a 3-week payment out to the expiry of the contract.
yes, if you want to look at it like that, that
Well,
is
you were,
correct.
no, sorry, that's what you were legally obliged to.
Yeah.
Looking at it the other
Yeah.
way, we can get into setting precedents that don't need to be set.
Sure. There was an entitlement, as there is in everybody's contract, to the 3 months in lieu. This was paid up. There was an entitlement to holiday leave. That was paid up. And I will have to clarify with Suzanne, if I may ask you, the specifics of the totality then. Because I'm concerned that I don't mislead the deputy in any way on this. There's 5 months' salary which was paid out in the contract. In addition to that 5 months' salary, there was 3 months. I think that's the question I'm being asked is, was that in addition to the 5 months' salary or part of the 5 months' salary?
In addition to the 5-month
Yeah.
salary.
So this is what I just want to be clear with you, Deputy.
Ms. Campion, can you please be clear? And we really need to move along with this. Can you be very clear as to what was actually
So
paid? Was there a severance payment here is what I'm asking.
There was no severance payment
On
full.
what basis can you make that statement?
I got legal advice on it.
Okay, so talk me through the actual payments. What did you pay for?
I'd have to get out the actual payments, but we paid full contractual entitlements, which included annual leave that was due to the CEO.
But the template contract clearly states that you can terminate on 3 months' notice.
Deputy,
Why did you pay over and above that?
The advice from our legal advisors was to pay full contractual entitlements and any holiday leave entitlements, which I believe was about 75 days as opposed to the 5 weeks the chair is talking to.
And so what is that payment classed as? Is it a severance payment? Is it a termination payment?
We classed it as pay in the accounts, just pay.
But it accompanied a termination letter.
Yeah.
And did the termination letter state reasons for the termination?
No, it basically said we are choosing.
And that's the basis on which you received legal advice?
Yes.
To pay out the contract. Okay. In terms of the investigation, so investigations and protected disclosures, you're running a cottage industry in protected disclosures, which I really hope we can draw a line under. The investigations, the 7 in total, 1 active. What's the status update on the 1 active case?
Do you want to take that, Suzanne?
Deputy, I believe that's a matter for the department. I think they have 1 active case. I think that's...
Secretary General, if you could confirm the status of the 1 active case.
So in fact, we have more than 1 active case, Deputy. I was just checking with my colleague there. So we have received 27 protected disclosures in relation to IFI since 2022, and of those 4 are still active.
That's the protected disclosures, but in your letter, you refer to investigations. So 2 investigations into the report 2023, 2 investigation reports 2024-25, 2 investigation reports concluded 24-25, and 1 investigation initiated in 2025 remains in progress.
And we've actually received 1 since that letter was sent to you.
So you received 1 since the 16th of January. And
the cottage industry continues, is what we're saying.
And was that a protected disclosure? An anonymous?
Well, we're processing it through our protected disclosure system at present. So we're examining it to determine whether it meets the standard for the protected disclosure.
And any investigations with the Gardaí? Have you had any updates from the Gardaí?
So just very recently, Deputy, as you may be aware, on foot of a closed investigation that took place, which involved the question of the insurance for a car that was involved in an accident. On foot of that investigation, and based on the conclusion of that investigation, I wrote to An Garda Síochána and referred the matter to them to ask them to look in to see whether there had been any criminal matter arising. They wrote back to us and said they required a complainant as such. We had some toing and froing with the IFI as to whether we would be the complainant or they would be the complainant. They didn't feel they could be the complainant on the basis they didn't themselves believe there to have been a criminal offence created. So on reflection and to having taken internal legal advice, on Monday I signed a letter to the guards saying they could take it that this was an official complaint, and that, so in other words, the department has taken on the role of being the complainant in this case.
Okay, and so that is now with the Gardaí?
Now it's back with the Gardaí.
Yeah. Okay. In terms of the IFI review, and you make reference to it, that we expect to see an external review being instructed once the new CEO is in place. It is great that we now have engaged a new CEO. Has there been any preparatory work done in that in terms of setting out the terms of reference for what that review will look like?
Could I ask my colleague Martina to deal with that?
Thank you, Deputy, for the question. We haven't specifically drawn up the terms of reference, but we have been referring, obviously, to matters such as the CNAG's report, to the various reviews that have been conducted in the past, and we'll be using that in conjunction with talking with the new CEO when he comes takes a position on the 13th of April. The Minister's intention is to write to the IFI after he takes up that position and to request that IFI would set up and run that review. That was the approach that was taken with the EY governance reports, that it's a matter for the organisation to have ownership for, but we'll be working with them in developing the terms of reference for it.
And I suppose in terms of the legacy of issues and obviously all the cultural issues that we've referred to, the department will be taking a very active engagement in that, I assume.
Absolutely.
And in terms of, I suppose, supporting the IFI through this transition period so they can get back to focusing on the day job, what does that engagement look like with the Department Secretary General?
Well, if I might go back to the EY report, because I think that's a good analogy. And can I just say, it is great that we've got a very strong CEO is coming in. Both Martina and I have worked with him in the past in An Bord Pleanála, so we know him ourselves. And it's going to be, what we are intending is that review will be as supportive of him onboarding into the organisation and making sure that he has a clear mandate to drive the sort of important changes both in the corporate governance side and the cultural changes that the colleagues in the IFI referred to. So in the EY report, now I wasn't around at the very beginning of that process, but the two Section 18 appointees, I think colleagues in the department worked with them on the terms of reference for that. Then were engaged in dealing with EY as they prepared that review. And then I know that I was briefed, for example, after the Section 18 inspectors, obviously, but I was briefed myself on the content of that draft report, just to make sure that we were comfortable with what was coming out of it, and we felt that it addressed all the necessary points in terms of the governance. And obviously our own department was reflected in it, so it was really important that that be there. So that's, I would anticipate that's the kind of hands-on approach we will have towards this, and I would certainly, for example, anticipate being briefed on the contents of that review before it is closed off.
Thank you.
Deputy Murphy.
Thanks a lot. Thanks for coming before us. Just to follow up a little on the payments to the former CEO, can I ask, was approval sought by IFI from the department for those payments?
It wasn't a sanction as such, Deputy, but the department, we obviously kept them fully informed of everything we were arranging with.
And did they sign off or indicate approval
yes,
of this process?
We have submitted material to that effect to the CNAG in a set of queries we had earlier.
And did you seek to have with the former CEO, obviously you were paying above and beyond what legally you were required to pay, did you seek to get an agreement that this would be a kind of full and final settlement, that no further money would be sought?
Yes, we did.
And was a document to that effect signed, or?
No.
Okay.
We did make a proposal of that nature, but it was.
You sought it, it was declined,
yeah.
But you decided on the basis of advice and so on that you should proceed with the full payout in any case. Okay. Just to go back then to the period from 4th of March 2024 to 4th of June 2025, when the former CEO is being paid, as I understand, being paid the entire period mostly at full-time salary, sometimes at some part of that at half-time salary. And what sort of leave was the CEO on?
We would, again, I'm conscious of the rights, even under data protection, etc., and confidentiality of the employee. But I could say in a general way that an employee in this nature can have, and I'm not saying this applied in this case, I'm not being, I'm hopefully pedantic in this, but clearly one can have sick leave, one can have holiday leave, one can have voluntary leave, one can have garden leave, and it was different combinations of those. To be frank, is what we all the time. I suppose it is important to say, and I think I can say this without impacting the WRC. We could have gone legal routes. We went into mediation. Mm-hmm. We could have gone legal route, but chose not to do that because of exposure to other kinds of costs.
At all times over this period, from the 4th of March 2024 to the 4th of June 2025, when he's being paid, at all times, somewhere it was registered that he's on a certain type of leave, without going into the distinction.
Yes,
And there may have been different periods of leave, but...
Absolutely, yeah.
Okay, and Ms. Campion, I mean, you're the finance person in this. You're presumably, at what stage are you aware that you're, signing off on the continuing payments of someone on different bases over time? You're kept appraised of that as that happens, or?
Yes, Deputy. The payroll comes through the Finance Department every fortnight, and it is signed off appropriately. The board dealt with the CEO. I wasn't involved in the dealing with the CEO, but the payroll came through as routine on instruction.
And did the payroll tell you that we're paying this person because they're on X sort of leave, Y sort of leave, Z sort of leave as the time goes on, or you're just paying and you know that the person isn't working?
Deputy, the instructions came from the head of HR, who was dealing with the board directly and categorised the leave.
Were you aware, as the person who signs off on spending money, you were aware of what sort of leave the former CEO was on, or you weren't?
It was leave,
You just were told it was leave?
paid leave.
I mean, that's the thing, the word just leave, now it's being clarified that there was designated types of leave. Obviously, your average worker in the state can't be off, public or private sector, on leave uncategorised for a year and 3 months, or a year and 4 months, getting paid. But you're saying that there was an appropriate categorisation. I mean, one can dispute whether it's accurate or not,
Sure.
but there was a certain type of leave at each moment.
Yeah, in all cases there was. In all cases, we had several special board meetings on this over the period. I think if you look at the accounts in 2024, there were 16 board meetings, or 14 in 2025. There were 16, and many of them were dealt with the situation concerning the CEO. The staff, my colleagues here, were not included in those meetings. It's one of the reasons I want to present myself here today, because they obviously didn't have access to the decision making because of the confidentiality requirements we were working under. But yes, in all cases, every move we made with legal advice.
And that's recorded in minutes, presumably, as to the different types of leave and so on. Okay, maybe just to zoom out a bit, because I do think in your opening statement you make very important points about the importance of our waterways, the decline in the quality, the points that you've made that I agree with entirely about the Boyne. I mean, it seems to me when you look at the numbers that you've presented, one frontline member of staff for every 315 kilometres of waterway and every 1,200 acres of lakes with coastline, estuarine and marine responsibilities on top of that. I mean, I wonder in some ways if some of the cultural issues flow from this. Is this an organisation that in terms of resources is set up to fail? A bit like the financial regulator. At some stage you had 3 staff sitting on Anglo and Bank of Ireland, and sure, there was no way they could properly regulate. Like, is that effectively what's happening here? Is that you're so under-resourced that you cannot protect our waterways?
It's a really interesting question, Deputy. In one sense, the scale of the job, you have to look at prioritising some parts of it. You almost have to say, well, we're not going to look there. You have to make very good decisions about technology. I think digital technology, real-time monitoring, this is investments that we need to make on top of the staffing resource. But in terms of being on hand to watch for massive, what I would always categorise as environmental crime. This is not negligence, this is criminal negligence. It is very difficult to be every place at the same time, for sure. It's a multiple thing. I should have said, and I do say in my opening statement, but I didn't say it in the verbal, we've been dealing with the department on new legislation. The Minister has specifically asked us to talk about fines. The maximum fines we impose for environmental crime is €5,000.
Yes.
This is derisory when it comes to major corporations, or indeed when it comes to any player. So there is a national debate needed on water. Now, we're not the only people involved. I should say we have the local authorities, we have the EPA as well, and increasingly we're working more and more with them.
And the European Commission has, or the report into the Blackwater has said we should have a 3% of annual EU turnover of the operator, which would be potentially very, very substantial, into the millions, depending on the operator. Why hasn't that happened? I mean, why do we have such pitiful levels of fines for environmental crimes?
It's partly historical. Like a lot of the things in IFI, it's I guess I can only say we are really confident that we're moving on this now with the department. And I think we will address it.
And just a final question. I mean, again, you referred to the Boyne. Parts of the Boyne, as well as 466 of our rivers, have been redesignated as heavily modified water bodies, which effectively means that they don't have to reach the same high standards of environmental health as other rivers and lakes. Does this, you know, and calling attention, and it's not you doing it, but we're calling attention to the declining standards of our rivers, in particular the Boyne, and then we're redesignating them in a way to mean they don't have to meet the same standards. Does this have an impact in terms of the work that you're required to do, expected to do?
No, I think on our work on rivers is so focused on salmon and on the salmonoid species. In the Boyne, I should have said it in my address, but I have it in the statement. We have a project led by a small team on the Knightsbrook River outside Trim, where people are restoring spawning grounds by literally importing gravel into the river. And it is, I saw the Boyne being drained in the 1970s, and it was a devastating impact on that river and on the landscape. Obviously, people who have been protected from flooding since wouldn't agree with me on that. But I would say that we probably need to really look at joined up thinking in this regard with, for instance, I suspect much of the flooding of the Boyne occurred by the depletion of the bogs to the west of Trim. So are there other ways of retaining a great cistern of water? The Boyne in the summer is reduced to a trickle. In the winter, it floods. So we need a management system that is very different. Sorry, I don't want to be, to be going on.
Thanks for that, Mr. Conn. Deputy Byrne.
Thanks, Chair. My first question is probably directed towards Mr. Fox. The last time you were in here, I raised concerns and asked a question specifically around the National Coarse Fishing Federation of Ireland in 2021, and did they have the sufficient accreditation programme in place, and were they qualified to deliver the tender specifications that had been awarded? You committed to circulating information on that back to the committee. I didn't see that response in the response to PAC queries that was sent on the 14th of January.
Deputy, if I may take that.
Briefly, if you can, yeah.
Yeah, it wasn't on the request for information, but I have it here if you want to take it now.
Okay, yeah, if you can just leave it with the clerk, I'll look up at that. That's appreciated. Thanks a million. Just in relation to the 2024 accounts, and I'm easy as to whoever wants to take this, probably yourself, Professor Collins. You know, you gave a lot of information and offered a lot of reassurance in your opening contribution about how the board will be judged on its effectiveness to clean up legacy issues and stuff. And there's many of them. And then on one hand you're saying that, and on the other hand your opening statement is effectively accusing this committee of causing reputational damage to your organisation. I think it's the reputational damage and the bad governance of the organisation that had you in this committee in the first place, and subsequently has you back here. So I do think you need to own that. But in the presentation, these 2024 accounts, the CNAG has drawn attention to multiple matters, yet again, not singular, like you're talking 4 or 5 matters here. We've got the issue of the CEO, which has been discussed. We've got the salmon research programme, lack of control of receipts and bounty payments there. We've got the costs in relation to the uninsured vehicle. We've got non-compliant procurement, yet again. We've got 277,000 in legal costs, and I believe you're awaiting court rulings and potentially more legal costs in additional cases. And despite all of that being outlined, all of you guys were in positions prior to the 2024. I think I'm right in that. I'm just not sure on Mr. McPhillips. I don't know if you're in a contract basis, but Professor Collins, Mr. Fox, and certainly Ms. Campion, who's been around a long time, have all been in your roles prior to that. So how can we have belief in the leadership? Like, how can we believe everything you said in your opening contribution, that you're ready to clean this mess up once and for all, draw a line under it, and that we don't see you back? I can't be assured that your 2025 accounts will reflect more favourably on you, considering the facts that are laid bare in front of us here today.
Well, Deputy, I want to be sure or clarify, nothing I said in my opening statement was of an accusatory nature. It was a clarificatory nature, and I would not even dream of going into that, that domain. Many of the issues, even that you do refer to, are actually historic. I do accept that some of them are current. The procurement one is definitely current. But the uninsured vehicles is not current, it's pre-24. The costs associated with it is also pre-24. But I'm not at all saying other than that. I'm accepting fully that the burden of proof is on IFI on these matters. Let me be very clear on that. The organisation...
So you're confident next year's accounts, the 2025 accounts, will not reflect as negatively on the organisation as 2024?
Yeah, absolutely. Can I bring in my colleague Suzanne on this one?
We recently provided our 2025 accounts to the CNAG for audit, and they do reflect better. There is a lot of matters closed off now, thank God.
Okay, and look, time will tell. That will be the judge of that. Thank you. I know your new CEO is due to take up their position in the coming weeks. Is all of your board and leadership positions now filled?
No, we're in process. We have 3 board members down. We're a small board anyway, there are only 10 of us. Last year, 3 members, for various reasons, one through sickness and ultimately passed away in January of this year. One for professional reasons, who changed her job, and one other member left for, I can't be sure exactly why, but I suspect she may have had some issues with some policy positions. So we're down to 7. We have the PAS, the Public Appointment System, working on filling those vacancies as we speak. On the senior leadership team side, we have the new CEO, obviously starting work on the 13th of April with us. We've begun an induction process with him. He has met the board already, met the executive leadership team already. We'll be meeting in the coming weeks individually with each of the board members. We are concluding a process which the CEO will be involved in filling the post of head of HR, or people and culture, and we're also coming to the conclusion of filling a post as head of ICT. But certainly we need to strengthen the senior management team, and clearly when the new CEO comes in, and has been mentioned, the review that was raised here. We would hope the review might also work in our favour and draw attention to areas where we do need new staff, new specialists and new experts.
What is the longest period that any of them senior leadership roles has been vacant or empty, unfilled?
Okay, the head of SST is a new role.
Yes.
The head of HR has been vacant. That we filled that post last year. It was filled on a full-time basis, initially on an interim basis, then on a full-time basis by the same person, but then that person left. So we now have an interim person in place. So the head of the HR function has never been, since I've been around, it has never been unoccupied, though not necessarily by the same person.
In the conclusion of your written statement, not your verbal contribution today, it says it can be reasonably concluded that Ireland will not reach its carbon, climate, biodiversity or water framework directive goals without robust environmental regulation. Have you had, I presume you've had communication with the department on what powers you might need to implement that, and what is the response been?
Yeah, we've engaged with the department. I consider we have a really positive working relationship with the department. The department wrote to us, the Minister wrote to us back in the end of last summer, looking for input from IFI on legislative changes that the department and the Minister was considering. We have made a detailed submission to that, and I think we've included that in the documentation we've supplied. We would be immediately saying the fines need to reflect, the punishment needs to reflect the crime, is one of our strong mantras around the environment. But we would also, it is difficult to bring a prosecution through the courts in the case of a pollution or a fish kill in particular without finding a direct source. I personally wonder if we shouldn't have powers of entering premises, of seeking documentation to try to pin actions of criminal activity or nefarious activity onto perpetrators. I know, Barry, you have contemplated the legal issues a lot. Do you want to maybe comment on that?
I think, Deputy, just on the the commercial premises, that's a matter for the EPA and the local authorities. But we are working with the department on increasing our powers around water quality and habitat destruction, and it's something that will add a lot of value to our officers and to the environment.
Thank you. And finally, I realise I'm running out of time. I did want to raise a few things with the department, but just because we're in the dying seconds of this, Professor Collins has highlighted they have a really good working relationship with you guys, and that's positive to hear. But considering the scandals, the constant scandals, and in the few years that's been in it, and as I said, I'm not ashamed to say in the beginning, I don't have the confidence that it'll be any better next year, but time will test that. I presume you're going to stay here today and tell us that you've got full confidence in the IFI leadership, or at any stage, I suppose, and this is what I want to tease out of you, was there any consideration of rolling up IFI and giving its powers to perhaps another state body like Parks and Services, for example, or something like that? If you could indulge me in that, Chair, just to get that answer.
Well, Deputy, given everything that's happened to the IFI, I'm not sure that we'd find a willing home elsewhere in the state apparatus.
Very honest.
But just to say, we have every confidence in the board, right? The board are a really strong board, and we're moving as fast as we can to fill those 3 vacancies that the chairman mentioned. We are appointing a very strong CEO, and he will be given every support by the department to get the job done within the IFI. We need an organisation with the role that the IFI have, but we need to update the 1959 Act, which essentially is what a lot of this work is based on. And the focus of that Act is largely around just illegal fishing. and it doesn't reflect the pressures that have been mentioned on our rivers, which is around pollution, climate change, nature-based solutions needed along the waterways, etc., etc. So now what has happened is we had been working on consolidating legislation, and then, of course, the same people who were dealing with the legislation were also then dealing with all the corporate governance issues. So one of the reasons for the split of corporate governance out away from the policy areas is to allow the policy team focus back on the policy. And then what the Minister is now minded to do is do a shorter piece of legislation first, which will address those fines and the enforcement powers and bring them into the modern era. And then we'll go back to the consolidated legislation and really do an overhaul of it. Now, it may be in the context of that, but that would be a government decision. It might be decided that, for example, there's an alignment needed with other agencies that have responsibilities in the river area, but that would be, I think, part of a broader reform. We're going to do the fines and enforcement first.
Okay. And keep an eye on good governance while we're
Absolutely.
Thank you.
Deputy Kenny.
Yeah, Gormagat, Cahirlock, and thank you to the witnesses, and thank you to the Controller and Auditor General for his report also. Mr. Collins, in your opening statement that you've written here, you said former Minister Eamon Ryan did not at any time commission a report into the matter of the uninsured vehicle, contrary to a number of assertions by a member. For the record, I'm presuming that I'm the member. You have said these inaccuracies contributed in many occasions at that hearing, where interactions between the IFI delegation and the committee were cross purposes and cast a very negative pall on the proceedings. The cross purposes, Mr. Collins, was your senior management team didn't inform the committee that in February 2025 they knew and they discussed the report that former Minister Eamon Ryan sent to the board of IFI. They were the inaccuracies, not mine. They were the inaccuracies. And it's as simple as that. I'd appreciate if you corrected the record on that. You have come in here and you've split hairs in relation to the inaccuracies at that committee. You didn't once say that the inaccuracies of the committee or that your senior management team did not disclose when I asked or when Deputy Gagan asked about this report.
Do I, if I can respond to that, Deputy, I have no wish for recriminations of any sort in this meeting. But I looked at that meeting as it unfolded from the comfort of my sitting room, and there was a question raised about a review commissioned by Minister Eamon Ryan. And I had been all over the review that you mentioned. It had come in front of the board. I had written a detailed response to it, but I didn't actually realise until well into the meeting what review you were referring to. Now, I think that's fair on both sides.
I think that's completely unfair.
Well, I'm only speaking for me.
One investigation was sent to you by the department in February 2025. I asked that question. What other investigation could I be speaking about?
There could have been multiple.
There wasn't, though.
But there could have been.
But there wasn't.
But, well, yeah,
there was
perhaps
one.
we'll just leave it like that then.
There was one. So there couldn't have been multiple. You said there could have.
Just for clarification, were there other investigations that you were dealing with at that time?
Well, can I intervene, if I may? We actually sent 3 investigative reports to the IFI.
The RSM investigation, because I referenced RSM.
Absolutely, and I'm not commenting on the confusion. I'm just saying that there were actually multiple investigation reports. So
But only one of those were conducted by RSM.
I can't say whether more than one was conducted by RSM.
RSM was involved in multiple investigations on behalf of the department. Some of those were shared with IFI.
One shared in February 2025?
Yes, RSM conducted that investigation on behalf of the department, and that was shared with IFI.
That was based off a protected disclosure made in relation to the uninsured vehicles?
Correct.
Yep. So why did it say here that former Minister Eamon Ryan did not at any time commission a report into the matter of the uninsured vehicles?
Strictly speaking, the report was commissioned by me as the Secretary General.
Yeah, but like we're splitting hairs there.
I'm just, anyway, I'm not commenting on the confusion.
Yeah,
I just
come off.
just,
Like That's completely and utterly splitting hairs. The department sent you an investigation. Mr Fox, Mrs Campion, why didn't you disclose to me at that time, or to Deputy Gagan? That was the report. You were present at the ARC committee meeting on the 24th of February. You were present at the board meeting on the 26th of February, but you failed to disclose at the committee, until the very end, Ms Campion, to be fair, that was the investigation.
Thank you, Deputy. Yeah, I'll take that question. Deputy, the reality was there was a lot of confusion around this discussion at the last attendance. The RSM report was never mentioned throughout that meeting. It was never referenced. The other points to make is that on 5 occasions the Minister's report was referred to. On 9 occasions, you actually talked about a second summons, and you asked me about a report into it. That's exactly what it says in the transcript. And the last issue was relating that the CEO had actually admitted that he knew about the issue of the uninsured vehicles on the day of the accident. That completely confused us on that day.
Did you fail to tell the committee that the RSM investigation was brought to your attention at the ARC committee meeting and the board committee meeting?
No, Deputy. I was focused on a Minister's report because, as you will remember, the meeting was quite intense. It was quite heated at times, or that's what we felt. And my focus was on, I was trying to remember what a Minister's report was. In fact, you may even recall I asked my colleague on the day, did she know anything about a Minister's report? So it was confusion.
The same colleague that actually did an investigation into it.
Well, you asked Deputy Gagan asked every member, every witness from IFI if they were aware of that report. And as we now know, one of the people that were in the room had actually done an FOI relating to the RSM report. And they didn't understand what we were talking about. So there was a lot of confusion, Deputy, and I apologise for that confusion, but certainly it was not intentionally done.
Like that confusion, it beggars belief. It was discussed at a meeting by the board and by ARC in February 2025. Like anyone within the room, with any sort of knowledge of what went on in the board meetings, would have known exactly the investigation that I was speaking of. That Ms Campion, you carried out a report on behalf of the board or ARC, I'm not sure which one it was, into this report.
Deputy,
and you failed to acknowledge it.
Deputy, what I can say is that there were 3 of us here at that meeting, and none of the 3 of us knew what a ministerial report was, what you were talking about. What I can say also is that there are reports generated by ministers that are commissioned by ministers. This was not one of them.
Hang on a second, you said there was 3 of you there that day, you didn't know.
We didn't.
Well, you said at the end of the PAC meeting, at the end of that meeting, to the chair, that you exactly knew what was happening.
No. At the end of the meeting, I said, I think that I know the report you're talking about, and I did a report on that. But that was after a lot of discussion and confusion.
So you did know at that meeting what?
At the end of the meeting, I said it must be, because it went on and on and on. But the discussion around it was constantly about a second summons. I had never heard of a second summons, and I certainly didn't do a report into it.
That was 2 separate conversations. The first conversation was in relation to the investigation that Ms Buckley now has said that she commissioned through her Minister Eamon Ryan at that stage. I'm presuming Minister Eamon Ryan was well aware of the investigation being
Absolutely not, Deputy. When you're dealing with protected disclosures, ministers aren't kept informed of those reports.
Minister wouldn't be kept informed of an external investigation that was commissioned by his department?
Absolutely not. It's a protected disclosure, so it's under the protected disclosure legislation.
So now you're becoming the complainant in this?
In this particular case, yes, we possibly in excess of prudence, we think that the guards should examine whether there was any criminal matter involved in this. That might well be an excess of prudence on our part.
Which criminal matter are you referring to?
The question of whether there was insurance documentation provided to an employee of the IFI and whether that was done knowing it to be incorrect and with some criminal intent.
Presumably you're putting yourself down as the complainant.
Yes.
The department fully believes so, that knowingly IFI produced false documentation to An Garda Síochána in relation to an uninsured vehicle.
On the balance of probabilities, the investigative report found that was done, although having read through all the documentation myself, you know, I can see why, for example, the chairperson himself doesn't believe so. Like, I think there is a very arguable case. However, in an excess of prudence, perhaps, having taken legal advice, we decided as a department that we would like the appropriate authorities, which in this case is An Garda Síochána, to come to a conclusion themselves.
So the legal advice of the department are basically saying that because of this investigation, they believe that the IFI knowingly gave false documentation to the person who gave the protected disclosure to the department in relation to the uninsured vehicle.
What the department believes is that there is a matter that it is prudent that An Garda Síochána be alerted to an
The
investigation.
department probably wouldn't take a case to become a claimant in a case with An Garda Síochána if they didn't truly believe that what went on is a matter for An Garda Síochána.
What the department thinks is that there is a matter that is sufficiently unclear that An Garda Síochána are the right authorities to make a conclusion. But as to strong beliefs or otherwise, we are acting out of prudence.
How many cases are the IFI currently involved in at the WRC?
We have a total of 9 cases that are currently in third-party
Are they
proceedings.
all staff members?
They're all staff members, yes.
So 9 currently. How many do you expect?
And a number of those, I should say, are legacy cases.
Legacy cases. How many do you expect to happen, to continue? Is 9 the only that you expect to happen now?
No, I think because some of those cases, Deputy, are legacy cases, when they're dealt with, I would expect that that number will come down.
So the 205,000 euros that's already been spent on the uninsured vehicles more than likely will probably go up based off one of those WRC cases.
Well, correct, Deputy, and one of those cases is before the WRC, so I can't really comment on that.
Do we have an estimated cost of how much will be added to the 205,000 euros in relation to the cost that's going to be incurred at the WRC? So currently 205,000 euros of the taxpayers' money has gone on the uninsured vehicle issue. How much more will that cost the state?
I'm not in a position, Deputy, to answer that because that's the matter before the WRC, and what an adjudication officer may decide as part of those proceedings remains to be.
So we could be looking at €250,000 euros.
I'm not going to speculate, Deputy, without due respect.
Perhaps could be, yeah.
Okay. Thanks for that, Deputy Kennedy. We're now going to take a short break for 10 to 15 minutes, so the meeting is now suspended. public session. And I call our next questioner is Deputy Farley.
Chair, and thank you everybody for being here this morning, and specifically to the members from IFI for coming back to us again this morning. Just a couple of points of clarification. First, has any members received training in preparation for this morning's appearance in PAC?
Yes, we have.
And who was that training by?
That was by a communications company.
Okay, and how much did that cost?
Oh, I don't.
We won't know until we get the bills, but it's charged daily for any days we use.
You would have had a price procured, I'd imagine, before.
Yeah, I do, and I didn't bring it with me, but I can check it out for you.
And was it 1 day's training or?
No, we got a number of days training.
How many? How many days?
I'd say 5 or 6.
We can get that detail for you, Deputy.
5?
I'd say it was around 5, Deputy, yeah.
So a week's worth of training?
Well, we were advised leaving the last meeting to reconsider our position regarding media training, so we took that advice.
Who advised you on that, Mr. Fox?
The Chair.
So you took the chair?
How ineffectual the previous training, I felt, Deputy Farley.
The previous attendance, there was no training?
It was a couple of hours, Deputy.
There was training paid for before the last appearance?
With our comms, with our internal comms, and with in external for about 2 hours. Yeah.
Okay. And so over the course of those 5 days, what did that training focus on? Who was involved in it? Was the board members involved? Who participated, and what were the modules of that training?
The modules of the training, Deputy, were very clear. It was to answer open and honestly to the committee, to think about our answers before we answer, to ensure that we gave you the correct information, to think and ensure we could find the information under pressure. And that was really it. It was to test us on, to make sure that when we come in here the next time that we would be in no doubt when we were answering a question to you, and that it was open, accurate and frank.
Okay. If you could follow up with the costs associated with that, I'd appreciate that. What budget line would that come out of, Ms. Campion?
Consultancy.
Consultancy fees, okay. And Mr. Collins, did you participate in that training?
For some of it, yeah.
How much of that?
Well, it wasn't days. I think more in terms of hours, probably 6 or 7.
Okay.
Of course, I should say, Deputy, I mean, this, I would contextualise this against the background of the last meeting that we discussed at the outset. For whatever reason, and I'm not going back into that, that was not a positive outcome for IFI. We would make absolutely sure, as a board, that the next time round we would try to ensure that any mistakes that may have been made wouldn't be made again.
And in that training, were you advised about the making of opening statements?
No.
And
not in any detail, no. But in a general sense, of course, we take as much advice. I mean, I'm struck by the question. If I go in to play a game, I am expected to have trained for it. If I go into an environment of teaching in a classroom, which I've done a lot of, I would expect that student teachers have gone through the training for it. I do the same.
If you read back on the transcript of today, with greatest respect, I have cast no aspersions or made no judgments. I've simply asked questions.
I'm not hearing you casting aspersions, but I'm giving you my rationale.
Yeah, but you're struck by the line of questioning. And in your opening statements, while you've rejected Deputy Byrne's comments that it wasn't of an accusatory nature, you have said that there was claims of misdirection by members at the last Public Accounts Committee. What would you define as a misdirection?
Well, first of all, I'm not sure how fruitful this line of discussion is.
That's twice now you've questioned my question with the greatest respect, Professor.
Yes,
could you just answer the question? Thank you.
If I'm asked a question concerning a report which is named definitively as being with one name and the report as a different name, that I consider a misdirection. I don't consider it necessarily even an inaccurate, well, it is inaccurate, but I'm not attributing any motivation to it. I'm simply saying it was a misdirection. If I'm driving down the road and I read a sign indicating that the local town is to my left, but the town is to my right, that is a misdirection.
Okay. Ms Buckley, when did concerns first come to light about the IFI to the department?
Very good question, Deputy. I think the protected disclosure, started coming in the beginning of 2022. Now, there was an incident involving a dormant accounts funding in 2021 that came to light as part of the accounts. But in the greater scheme of things, that didn't appear to be, as significant. Perhaps it should have been reflection. But no, the flood of corrected disclosure started in early 2022. I would say February 2022.
And hindsight is a great thing. Should the department have done more sooner with regards to the IFI, do you think?
Well, I think actually, Deputy, the department now, this predates me, I should point that out, so I'm speaking from records and memory, but the department actually did act extremely swiftly by the standards of this. So they, I mean, you can think about already by April, so February to April, the department had written a number of letters, was commissioning reports, without necessarily linking the two things. The department wrote an extremely serious and trenchant letter to the chair of the board on the 27th of April, and the chair of the board resigned the following day. So, I mean, it was a very significant amount of effort was placed into investigating the events surrounding this, because, as you can see, these really serious disclosures were arriving. And if you think about it, I mean, the department has an oversight role and it has a governance role. It's not in the weeds. It can't be running the place. In terms of, and also there is a board there for a reason. So the department acted to see whether the board could address these things. And I would say did so quite fast. And then obviously within a year of the first disclosure arriving, the Minister had acted on a no-fault basis to, in fact, remove the entire board, replace it with the Section 18 appointees, and then move to appoint a brand new board to address all of that. They hired a senior counsel to do a report into the activities of the board, and that report arrived in the summer. When the Section 18 appointments were made, they then required the EY report to be procured by the IFI, and has worked very strongly and closely with the board to ensure that those EOI results are implemented. So actually on this one, I think the department has quite a good story to tell, would be my view.
Following the meeting in December, did the Minister or the department consider at all seconding staff directly into IFI to allocate resources to put a bit of added kind of attention to the organisation?
We certainly didn't consider seconding staff from my department, no. What we did have some discussions with the Minister as to whether we would appoint a temporary CEO, but at that point the CEO process was so far advanced, we felt that our efforts were best spent just trying to get to the end of that result. Yeah.
Mr. Collins, in your open statement, you were kind of at pains to say that with regards to protected disclosures, there's no limits to what people can do, I think is what the words you said. And I was inferring from that of the 38 disclosures, I think people could have made multiple disclosures. Is there a rationale for saying that? Could that have been 38 individual disclosures, or why would you make a statement like that?
By definition, I don't know until I get a report. And I won't always know it, even with the report in the board, where a protected disclosure arises from. So I just don't know. So the rationale is purely based on the possibility that one person could make and can make multiple protected disclosures, particularly if they're anonymous. So I can tell you, Deputy, for instance, that of the protected disclosures that we got between 2022 and 2025, as I mentioned earlier, 29 of the 38 are anonymous. So I don't know. I really don't. It's a possibility, but I can't speculate on it, Deputy.
Just for a point of clarification, Chair, and I'll finish at this point. Were all of those protected disclosures considered? Like, who made the determination on the thresholds for those? Just for all of those?
No, absolutely. As a board, we are obliged under the Act to designate a person to manage protected disclosures. We have such a person designated in IFI. Last July, because of the numbers coming in, but also to open up, make it easier for people, actually, we create a portal online so people can make the protected disclosure into IFI via the portal. And that's managed by an external agency, by PwC. So that's how it's managed. They will do an initial assessment as to whether this meets threshold. Sometimes they might say it's actually really a HR matter. If it's a named or signed protected disclosure, at that point we will write back to them and say this. But they may, of course, advance them to be managed under the protected disclosure processes within the organisation if they reach that particular threshold. As I mentioned, of the numbers we've had, we currently have 3 under investigation. We've had 2 that were partly upheld and 1 upheld of our protected disclosures. That gives you the up-to-date picture on it.
Thank you, Ms. Buckley. Thank you.
Thanks for that, Deputy Farley. Deputy Dolan.
Gurmagat Cahirlook and Gurmagat to both the department and everyone from IFI who's here today. You know, I think it's been well aired and discussed over the last few weeks and months about, I guess, how frustrated us as members found the first meeting with IFI. And in fairness, I want to thank IFI for the continued engagement with the committee and for working to respond to a lot of our questions that we put to you in writing as well. I'm going to be going through 3 issues today. The first issue is section 6.31 of the CNAG's report. On the 4th of December, I pursued a very specific line of questioning on that, where I had perceived that there was an overclaim or that there was some wrongdoing in terms of mileage claims by an individual. At the end of that discussion, you had agreed, Suzanne, maybe that you would go back and review that matter to make sure, I guess, that you had full clarity of what the actual story was. Because I remember I was incredibly frustrated by that on the day. It's important to note that since then, the CNAG has issued a clarification on the title of that section of the report. And also I've withdrawn my remarks from the 4th of December. But I guess there was a commitment to review it. What did your review find?
Our review was conducted immediately after the meeting and it was passed to the CNAG's office, and the CNAG offered the clarification thereafter, and we're completely in agreement with the CNAG that it was unnecessary, not irregular expenses, that the expenses were properly constituted and signed off and approved and paid by Inland Fisheries Ireland, but it did point to inadequate controls within IFI.
Okay, so those mileage expenses, and just so I have this correct, can IFI confirm clearly for the committee that the individual in question did not breach any IFI policy, rules or procedure in submitting those mileage claims?
Yes, Deputy.
Yeah, so they were abiding by the policies.
Yes,
okay, because that's really important for me to clarify, because I think when I started my line of question on the 4th, I was of the opinion that this was a massive breach, and obviously that isn't the case. But I think it has highlighted, as the CNAG has said, you know, that this is maybe a systems failure by IFI that maybe shouldn't have arisen. The other point I just want to, I guess, make on that is, when you had previously received the report and you were in possession of the report for 5 months or so, had you ever raised any questions about that section of the report, or did you accept that as it was?
We accepted it as it was, Deputy. We looked at the content of 6.31 to 6.33 as the narrative.
Okay, understood. Because it's just, you know, I think it's really important that, you know, when you would have been involved, say, in the organisation during that period that those mileage claims were submitted.
Yes, Deputy, but I wasn't.
That was in the normal
post,
course of business, though.
But I wasn't in post at that stage.
Okay. No, it's just I wanted to clarify that matter because I do appreciate your response on the matter. I do appreciate the CNAG's clarification because I think there was confusion on my part in the line of questioning that I took, but also I wanted to make sure that I got it clear today for the record that that individual hadn't overclaimed, as I had said, and I know the answers I got on that day allowed me to pursue that line of questioning, and I stayed going down that line. Yeah, I just wanted to make sure that that was abundantly clear today for IFI and its staff. The second issue I want to move on to is the CEO payments. Did IFI seek approval from the department on those payments, and did you receive that approval?
I will deal with that, Deputy. Sorry, Barry, yeah. I would say, if you were to say, did we specifically write to the department and said we were seeking approval for X or Y? No. Okay. We kept the department informed right way through.
Okay. So say then, right, if the former CEO's employment ceased in June 2025, why was he paid until the end of November 2025?
It was our legal advice to try to reduce exposure in the event of a challenge. And of course, as we now know...
Yeah, and I'm conscious of that. I understand that this is before the WRC, but there was legal advice given to IFI to continue paying the CEO up until November.
Yeah, the CEO's contract ended in November, on November the 30th.
When did the contract end?
My understanding is that it finished on the 4th of June. There was a lump payment.
Sorry, yeah.
So he didn't continue in payment until November.
Okay.
He was paid a sum in lieu of payments that might have accrued to him if his contract continued to the end.
Okay. Okay. So was his contract due to end in November? Okay.
Yes.
That's clear. Do IFI and the department agree that this arrangement was a termination or severance payment, as payment was made as a part of an arrangement to end his employment in IFI? So do the department have an opinion on that?
Yes, I might handle this one. As far as we was concerned, and we looked at this very carefully, as the chair says, they did keep us informed. This did not form a severance payment per se, because if it were to be a severance payment, it would, under a circular from 2018, Circular 9 of 18, have required the sanction of both parent department and the Department of Public Expenditure and Reform.
Okay.
Having looked at the matter, we felt that it was within the board's rights to determine that they could make this payment in the circumstances, and it wasn't, strictly speaking, a severance payment. There are, I can't, again, go into the details, but just to talk more in the generalities, and I've been involved in these circumstances, both as the severancing body and as the parent department. So the circular expresses that in very, very limited circumstances, a severance payment can be agreed by way of legal agreement between a public servant and their parent department, normally if the relationship obviously is broken down for some reason. In my experience, PER apply a very strict set of rules around severance. The rules were actually negotiated, as it happens, ironically, by me in a previous job when I was in PER myself. And they're known as the HSE terms. So there's strict rules about what they will permit in terms of severance based on length of service and quantum of weeks relative to that. They don't allow, for example, in my experience, for there to be any enhancement to pension or anything like that. You have to make a very strong business case for that to take place, the actual terms of the agreement of the severance have to be sent to both departments and approved by both departments. And in my experience, they can recommend changes, in particular around transparency, has often been the case.
Okay.
So as far as we were concerned, we were kept informed of what was going on, but this was within the rights of the IFI to make this payment and didn't amount to severance.
Okay. And so the department, ye didn't sanction the former CEO being paid for those 5 months. That was an executive decision of IFI.
Correct.
Or a board decision of IFI, decision of IFI to pay the individual out to the end of contract.
Plus his other statutory entitlements.
Plus any other entitlements. Okay. Last topic I want to deal with is particularly around the IFI credit cards. And there's just one thing that I found interesting about it. In 2020, IFI had made 53 credit cards available to its staff to use, and there was a combined spend of over 148,000 on those cards. By the end of 2024, IFI had reduced the number of cards in operation down to 17, so that's 2024. How many cards are in operation right now?
There's 3, Deputy. We've reduced it down again since our last attendance.
Okay, and I mean, what was the rationale for the number of credit cards that was in use? And primarily, what were they used to spend on?
Yeah, I wasn't in the organisation at the time, Deputy, so I wouldn't have that knowledge. So I'll ask Ms Campion maybe to speak to that.
Deputy, Fado, there was imprest accounts given to a lot of staff who were on field work, and it was proving incredibly difficult to get the claims back on imprest accounts. So credit cards replaced imprest accounts, and they were gradually, I suppose, reduced. The main thing to say is that pretty much everything that goes through a credit card is through the normal procurement procedure. So if you need quotes for a purchase, you still need it if you're doing it by credit card.
Okay, yeah, that was going to be my next question was there levels of spend on these credit cards that warranted procurement? The only concern I have is that there was 53 credit cards in 2020, 148,000 spent. When the credit cards came all the way down to the 17 credit cards in 2024, there was still over 100,000 spent on them. And so that indicates that the concentration of spend on those 17 cards was much higher. And I just want to know, on what basis are the 3 cards remaining used for today?
Deputy, they're generally used for like IT purchases that you can't, they have to be online purchases basically. Okay. And they're the big ones. So as I said, we only have 3 and they are concentrated. Myself, Barry, my colleague, and one of the other heads of function hold the credit cards.
Okay, Garmagat, clear.
Thanks, Deputy Dolan. I think Deputy Neville has to leave, so our next questioner is Deputy McGrath. Are we going to swap?
QPL probably in 2 minutes, if you don't mind.
Are you before me now?
Sorry, Deputy Bennett.
Deputy Bennett,
he's ahead of you, sorry.
No,
you threw me there a little
be
bit.
back.
Deputy Neville, Deputy
And
Bennett, sorry.
If I'm not,
Then I'll go, yeah.
Back. Okay, mate. Okay.
You're before me.
Okay, thank you very much, everybody, for coming in today. So my first line of questioning is just going to be in relation to the fines. Whenever you fine somebody, I'm just wondering, how do you, in your opening remarks today, you said that prosecutions up to 5,000 can be give to somebody in relation to an offence, and that you wanted recommendations to increase that to 3% of your annual turnover. So I'm just wondering, what mechanism would you use to do that? How would you do that? Have you legislation already in place to do that, or how would you do that?
Yeah,
Barry, go ahead.
That's under the Environmental Liabilities Directive. It's a recommendation out of the Joint Research Centre review of the Blackwater fish kill.
Okay.
So that's
When did that recommendation come, Barry?
it's part of the Act. It's part of the Environmental Liabilities Directive.
Okay.
The recommendation was January of this year.
Sorry.
So January of this year. So then, Barry, you have the legislation, the powers at the moment, you have that there to actually increase fines above 5,000. That's actually in situ at the moment. You have that in place?
No, Deputy, we don't. We in summary conviction in the district court only up to 5,000. If we went to a higher court, there is an opportunity to pursue it. But the review of our legislation will align our breaches to the Fines Act, which will give us increased fines in the future.
Okay, so you don't have that legislation in place at the moment?
We don't use it. It is used with other organisations.
So you have the legislation in place?
No.
You don't have the legislation?
We don't use the ELD at the moment.
Because I am just wondering, in 2013 you did run public events in relation to modernising your legislation, is that correct?
In 2013?
2013.
I wouldn't have that detail with me, I'm not aware.
Nobody knows? I don't recall, sorry. Okay, and then, so you don't know, okay. And then for,
We've had long-standing plans to update the fisheries legislations. It's never reached, unfortunately, the top of the priority list. So
how long has it been? How long?
Oh, I think probably going. I mean, the legislation dates from 1959, so I would say some considerable period of time. But and we have been working on consolidating the legislation, albeit it's never reached the top of the pile, if I put it that way. However, Minister of State Dooley is very, very clear now that, particularly on foot of the Blackwater and the report we got from the European Commission, he wants us to advance as quickly as possible the enhanced fines legislation. So now we've managed to restructure the department, so corporate governance has gone elsewhere. The team that are now responsible for inland fisheries policy will be in a position to start moving forward on that.
Okay, and is that included, have you that listed in the legislative agenda?
Yes, it's on our legislative programme, yeah. And it's a commitment to the programme for government.
What year was that placed on that? What year was it placed on the agenda?
Placed at the end of last year.
End of last year, yeah.
Last year, so it's end of last year, so.
It's put on the legislative programme for this year.
Okay, so it's on the programme for this year?
Yes.
Which month's that coming up, or?
Well, we're hoping that the heads of bill will go to government for approval as part of the summer programme, so in the coming months. There's a meeting with the Attorney General's office today just to firm up around that. So then we look to progress the legislation over the latter part of the year.
Okay. Okay, that's fine. Okay, I just wanted to talk to you then in relation to the IFI. Like, we do need the IFI. I definitely, I know that, and from talking to different people over the last few weeks, I do realise that the IFI is necessity. It just worries me. It just worries me in relation to everything that has went on, you know, beforehand. But you've given a clear outline today to my colleague Joanna Byrne that moving forward is going to be a different story. I just want to ask in relation to Fáilte Ireland. Do you have a relationship with Fáilte Ireland and the need to, I suppose, increase angling and tourism industry in Ireland? Is there a relationship there, or how does that work?
Yes, no, we would engage regularly with Fáilte Ireland, Deputy, and when we're doing international events, we would liaise with them on stands and stuff like that. A lot of the development of our domestic recreational angling, I said, bringing new entrants into the sport, etc. That's something we do ourselves, and we've just recently established a new unit in IFI, which is actually going to drive that throughout the country.
Okay. And then just, and have you a plan and a strategy? Like, is there a plan for that? So
the person was appointed late last year, and they're working on that strategy at the moment and how that's going to be rolled out. So it's going to consist of angling and education in schools, which we do currently, but a kind of a more ambitious plan, and then the development of opportunities to partake in recreational angling and working with our stakeholders to actually drive that.
Have we deadlines and numbers where what we're at? Like, do you know what you're doing over the next 2 years?
We have clear metrics. Pardon?
You like key performances indicators?
We have in relation to the education and outreach, but the section we've just set up is working on that strategy at the moment. So we will be reporting.
Because I have been told that tourism, could create a lot of tourism within the whole country, you know, in relation to the fantastic assets that we have, you know, that IFI are in charge of. So I just want to ensure that would happen. Just in relation to, you mentioned the angling facilities that are available at the moment. Has there been much, I suppose, have you increased that over the period? Has there been increased fishing or angling resources put in place?
So we would work a lot with stakeholder groupings around the country in developing angling opportunities. We have a lot of infrastructure that we maintain on an annual basis, and that would increase depending on what happens year on year. You'll be aware a lot of these infrastructure pieces get damaged from time to time. So our staff go in and ensure that they're in good upkeep. But certainly in regards to the angling product itself, it's really, we're focusing on natural fisheries. So wild brown trout, wild salmon, coarse fisheries, pike fisheries, and we'll be working consistently to try and develop those to increase productivity.
Yeah. How many development staff have you got?
The actual number, I think we have, I don't think I have that number to hand, Deputy, but I think we would have roughly about 40 development staff nationally.
Okay. And has that increased or decreased in the
It's
last
kind of
10
held
years?
level, so we have any of the new entrants coming into the organisation are dual roles, so that number would continue to increase. So it's part of a fishery officer's role. They would be dual doing fisheries protection and development. So we can access a lot more staff when needed.
In 2021, Inland Fishery opted to not reapply for the dormant accounts funding for the education outreach programme. By all accounts, it was a great programme. It was built upon Dublin Angling Initiative, engaging groups in the Irish Wheelchair Association, Traveller Community Groups, Acquired Brain Injury and Garda Youth Division. I'm aware that engagements with Dublin Angling Initiative have continued. Would you be able to provide an overview or contrast of the education and outreach programmes in, say, 2020 to 2025? Have you still got outreach programmes? And can we get a view of the levels of activities in regards to these, please? Yeah.
Yes, Deputy. So the Dublin Angling Initiative is still running, and it's very successful. And they ran a very successful event, actually, I think it was last weekend in Dublin, with about 130 attendees in the Dodder River. So it's very well received in that regard, and they do a lot of kind of school visits and kind of touch tanks and different kind of education pieces around our native fish species. Our regional staff then go into schools and do our Something Fishy programme. And that's outside of the dormant accounts funding, but it's something that we actively do every year.
So has there been an increase or decrease in the education outreach programme?
It's probably held steady, Deputy, if I'm honest.
Steady.
Yeah.
Okay. That's okay. Thank you for that, Brian. Then just also in speaking to anglers, I've been told that the bylaws 806 and 809 are counterproductive in terms of the lock curb. And they're providing a blanket legal protection to coarse fish across the state. They in fact provide legal protection to water and invasive species in that lock. So can you maybe, in a meeting of your board in February 2024, there was to be a public consultation in relation to that. I just wanted to have an update on that, on the status of that, and if there was a public consultation in relation to it.
So yes, Deputy, there was a public consultation into it, and we consulted on the amendment of both bylaws. Yeah, you might appreciate it's quite a complex area with competing priorities, as I'm sure some of the deputies are aware. Again, in Loch Corrib is probably the premier trout fishery in Europe, if the truth be told. It's an exceptional water body. Sheelan would be a similar note. There is work ongoing in trying to assess those consultations. There was significant interest in it, and we are going to be drafting a plan soon in the next couple of months.
That was in February 2024, so nothing's
No, the consultation closed just before Christmas, or we started that process then, Deputy, went to consultation in 25, but we have to put a plan in place on how we're going to deliver this. And legally it's quite complex, and with our stakeholders it's exceptionally complex.
So what deadline are you giving them then?
We will have decisions made and go back out to our stakeholders, I would say before June, I would hope.
Okay, thank you very much.
Deputy McGrath.
Thanks very much, Cahirlock, and thank you all for being with us. I'm one of the last speakers, but I'll try and ask some relevant questions. Can I just go back to, I suppose, the opening remarks by Professor Collins, and just in relation to the protected disclosures. I think the total was 38 to date, is that correct?
From June 2022 to 2025, Deputy, yeah.
Okay, over that period, okay. And in terms of us, extrapolating from that in terms of the culture of the organisation and so on, you made the point that they don't all necessarily come from different sources. Can you elaborate how many sources are we talking about in terms of those 38? How many different sources would be involved?
Yeah, Deputy, I honestly don't know, because I can't know if, as I mentioned, 29 of these are anonymous.
Yeah.
So I just don't know how many different people would have sent in, or anyone, as I mentioned in the opening statement, could submit multiple disclosures. So I truthfully don't know, and we've no way of knowing.
There's no way of knowing that. Is the department able to clarify around that issue? How many different, like, could the one person submit 39?
Oh, 100%.
But
Absolutely.
can we say if that's the case?
Without going into any great detail, Deputy, the nature of the disclosures is such that they definitely come from multiple people.
Multiple people?
Yeah.
Okay.
But it was probably fair to say that of the 27 that the department has received about IFI, some are anonymous, but some of them definitely come from the same pen.
Okay.
Okay, same person is behind them.
I'm just trying to get a sense, is it one person with a particular agenda, or is there multiple sources here?
There are multiple sources.
There are multiple sources. Yeah. Okay.
Maybe just to clarify, the department has received 27 disclosures in relation to IFI. That's separate to the numbers that IFI have received directly. There may be some overlap in terms of the allegations made. We have had 9 anonymous disclosures among that 27, so about a third of them.
Okay.
And the ones that come from multiple people.
Okay, so just to clarify the overall number, you have 27 and IFI have
38.
Yeah.
So 38 and 27 need to be added, yeah? Okay.
Yeah, although there could be overlap between the two. I don't have sight of their disclosures. They don't have
So that's
sight of ours.
65 protected disclosures in total.
It would be fair to say on some occasions when we've commenced investigations, our investigators have then found out that the same matter has already been investigated by IFI.
Yeah,
So there definitely
okay.
has been overlap.
And have we any sense of how many have been determined, how many have gone through the system?
Yes, so we have 4 that remain under investigation of those 27, one of which has only been received in very recent times.
4, okay. Is that to say that the others are concluded?
Yes, they were either determined not to merit investigation, so they didn't meet the standard of protected disclosure,
Okay.
they didn't come from the right sort of person, or they have been investigated and the investigation is complete, and any recommendations lying from them have been communicated as necessary.
Okay, thank you. Can I just go back to the whole chief executive issue and the payments in terms of the end of his tenure, the end of the tenure? You mentioned, Professor, in relation to the various types of leave, and I know you were cautious in terms of what you said due to the ongoing issues, but I think it was fair to say you said there were a number of different categories of leave involved in that 15-month period. It was also said in terms of the severance payments and the overall concluding payments that there was annual leave of 75 days included in that?
78 days.
78 days, so that's over 15 weeks annual leave was paid in relation to the final package. So is that to say that the 15 months leave, none of that included annual leave?
Sorry, Deputy, I didn't hear you.
15 months when the individual was not working, none of that period included annual leave?
No, that was paid leave.
Yes, I know it was paid leave, but it didn't include...
The annual leave was additional.
Yeah, so there were different types of leave involved, but none of it included annual leave.
Yeah, that's correct, yeah.
Okay, so somebody was out of the organisation for 15 months for various different types of leave, which had been approved in terms of going from one type of leave to the other.
Right.
But at any point was it suggested that annual leave might be taken when there was 15 weeks accumulation?
Only at the end when the calculation was finally done.
How much annual leave did that position hold per annum?
It's my recollection is 30 days.
30 days.
30 days.
Yeah.
So there was an accumulation of 78 days at the end. I'm just making a point. If someone is out for 15 months, it might have been suggested that some of that annual leave would be used as that part of that process.
Indeed, yeah.
It wasn't, so we decided to pay 15 weeks of additional
it
salary.
wasn't, yeah.
Okay.
You may not be aware that when you're on sick leave, your employer is not entitled to apply, like you accumulate your annual leave.
No,
and
I
your employer's
understand
not
that.
entitled to it.
Annual leave
Yeah,
is accumulated, but there were different types of
That's
leave
true, yes.
involved in this case.
That's a valid point.
Okay. Can I just turn to the delegated authority issue? And the CNAG has highlighted that €277,000 was accounted for in 2024 accounts in relation to abandoned cases and illegal costs. Is there more to come on that in terms of legal costs?
Yes, Deputy. There's still 5 cases to be finalised, and they will accrue additional costs.
Okay. And in terms of the 270...
Deputy McGrath,
just for accuracy,
Sorry.
that 277,000 wasn't accounted for in full in 2024. Some of it was paid in 2023 and some of it was paid in 2024.
Okay.
Just to keep the
it's over
thing
that period.
accurate,
Okay. How many cases would have been involved in that 277,000?
There's 56.
56?
Yes, Deputy.
Okay. So and there's a further 5 that are unresolved?
Yes.
And there will be additional legal costs involved in them?
Yes, they're awaiting what's called finalisation. So it's agreeing costs, basically.
Okay. And that will be costs from the IFI side and from the defendant side?
Yes.
Okay. Okay. Just moving on to a separate issue, I suppose, in relation to the collision that took place in 2021. Again, it has been highlighted in the 24 accounts, 205,000 spent to date in relation to that collision. Is that the totality, or is there more to come on that?
That's the totality in relation to the accident, Deputy, but there are other processes ongoing.
Yeah, and I understand there's a WRC process. Can you give us a breakdown of the 205,000? What exactly was that payment about?
I'll ask Ms. Campion to give you that breakdown.
Insofar as you can.
Can I find it now? Deputy, please bear with me, I do have it.
I might just turn to the Blackwater while you're looking for that, if I can. So again, Professor Collins, you mentioned the Blackwater and the catastrophe that happened there last year, and you did mention the independent review that the Minister asked would be carried out. I think you used the phrase that by and large it, endorsed the IFI's role in that. I suppose if by and large isn't 100%, what elements of your role did the report identify as potentially where improvements could be made?
I suppose 2 in terms of the response and perhaps a number in terms of preventing it again. In terms of the response, they are the absence of an interagency crisis management protocol. They alluded to that very strongly. And actually, even from my position during the Blackwater fish kill period, and I actually went down to Mallow to the meeting which the Minister convened, and heard the dismay in the locality with this catastrophe. So the JRC absolutely pointed to a need which I think we had already identified, that there need to be an interagency protocol, different players of different roles, but in that kind of protocol you need a lead agency and questions of, for instance, can the lead agency dictate to testing, when testing will happen? Can it dictate that laboratories that might be available to one agency would now be devoted to this?
Yeah,
so this is the kind of...
just because I'm caught for time, I don't mean to be rude, but in terms of the IFI's ability to get to the root cause of the pollution source, will the changes recommended improve your ability to do that in the future?
In terms of technology, yes, they should. They make several recommendations about real-time monitoring.
Because I think that's the biggest issue for the public in this, that such a catastrophe can happen and there's no source identified in terms of the cause of that.
Yeah, and the JRC do point that out in their report, that it could happen again.
Could happen again.
Yeah.
But you're saying you're better equipped as a result of...
I'm saying the recommendation is that we better equip ourselves with real-time monitoring and basically with technological
But you're not there yet in terms of...
No.
How long will that process take to be better equipped?
Can I
Yeah.
That recommendation is actually directed at the department.
Okay.
The department has to designate a responsible body to do that. That's going to take, and then resource them to do it. That's going to take a time as we work through, because there's lots of potential stakeholders here and lots of bodies that have responsibilities in this area. So that's a job we will be working through this year.
Okay, this year.
Yeah.
Okay, thank you. And perhaps I might get an answer to the breakdown of the 205,000, sorry.
Yeah. Legal costs were 26,898. Settlements, 135,000. All other costs, 42,738, giving a total of 204,637.
Okay, thank you. Thank you, Chair.
Deputy McGrath, Deputy Neville.
The other.
Sorry.
Sorry, Deputy, there was also repairs to the lease vehicle, which brings it up to 229,000. Yeah.
229 is the totality there. Okay.
Thanks for that. Thanks, Deputy McGrath. Deputy Neville.
Yeah, thanks very much. I suppose, to be honest, I was just struck, in fairness, by the opening statement, you, Ms. Buckley. Just in the words, it says, as in the case with all aegis bodies, it is important that the organisation operates to the highest standards of governance, accountability and transparency. The department takes its responsibilities. What do you think of that statement in relation to? Yeah. Have they behaved as the entity operated to those standards that you would have thought they should have in that period, in the last 10 years, 15 years?
Deputies, my statement also makes clear we don't think so. And as the actions of the department took in the period from 22 and then to the point of replacing the board and asking them to do very severe changes to the governance of the organisation. So our concerns became really clear in early 22. And the department has acted thereafter to try and secure the IFI, to bring it to a place where we can say that they meet those standards. And one of the most important acts we did was to put in the chair and the board and task them very particularly, as the Minister has done also, to lead those governance reforms that are needed at a central level.
And then, look, and to be honest, you've obviously, we could talk about people being replaced, but there's probably still a lot of people who are still remaining in the operation, because you can't force people to leave. How do you believe the mix of cultures will be able to operate, and do you think it'll be effective in essentially, for want of a better term, cleaning up what has happened, or ensuring it doesn't happen again?
So I think the first thing to say, of course, is that, as happens always when you've got a corporate governance issue in an organisation, the vast majority of people who employed that organisation are just doing their day job and they're doing it well and they're out in the rivers, and we've heard all of that from the chair. The problems that have arisen here seem to have largely been within the sort of central organisation of the body, and there's been a litany of issues around that. But I have confidence in the board to lead, and I have confidence in the incoming chief executive, who I know personally is a very strong incoming person, to lead this organisation. And I believe that between the board and the new chief executive, and with careful oversight by the department, and we have an oversight role, we can't be doing the job for them, we will equip them with the tools that they will need to get this job done.
Yeah, because look, and I know the board aren't going to be as hands-on just by the very nature of a board, and I do understand that as someone who's worked on board members of different entities, and it has been my own financial background. I've been operating companies where there's been a board. A board is always that bit set, and I almost feel sympathy for the board answering for day-to-days, because ultimately, they're typically not involved in the day-to-day in a way
100%,
that they couldn't be expected to be. Yet often in a situation like this are called upon to answer questions that they haven't involved in the day-to-day decision making, because ultimately the board operates at a remove.
So a strong executive is important, and it's worth bearing in mind, I think, and with due consideration to the staff from the IFI who are here. I mean, the IFI has been without an effective CEO for some considerable period of time.
What's
at this
the full
point.
length of time, actually, just to remind
March 4th, 2024.
So nearly 2 years. 2 years.
Over 2 years.
Over 2 years,
Over 2 years without a CEO.
And with the best will in the world, when you appoint temporary CEOs or temporary deputy CEOs, they just don't have the authority to lead the changes that you need. You need a full-time person in there with a mandate to deliver on what's needed.
And then Barry, how long have you been there actually?
I started the organisation in July 23.
So I suppose you've seen a lot of the turmoil, during that period of time, I would say, yeah?
I wouldn't.
What's your own thoughts on it? What you walked into, was it what you expected?
I suppose I started my career deputy in in the regional boards, which was the previous inland fishery structure. I think the organisation on the ground has been doing an excellent job and was when I came into the organisation. There were certainly issues, there's no doubt about that. But I think with the Section 18's being appointed, the new board, and the support they've given to the staff and the executive, things have progressed quite well.
Would you say it was a failure at the top then, rather than across the board, where that got us to this situation?
Deputy, I wasn't in the organisation when a lot of these
I'm just asking
issues.
your opinion.
Pardon?
I'm asking your opinion.
I wouldn't be comfortable sharing an opinion,
Okay,
Deputy.
that's fine, I just asked. That's okay. So just going back to it, there's so many financial areas, and I suppose someone who comes from a financial background myself, as an ex-auditor, it's all jumping out at me, the credit cards. Like when you hear the number of credit cards, I never allowed credit cards when I was working at any company, because credit cards are just ripe for, for people to be using them when they shouldn't, and it's impossible to follow and impossible to track. So ultimately you've gone from a situation where you went from 53 to 17 to 3, is that correct, the credit card? And that makes sense. I don't know how it was 53 in the first place. Just who would be responsible for insuring vehicles?
Deputy, we have a fleet manager or a field services manager, and he looks after the insurance.
And would they be, so are all the vehicles insured at different times, or
No.
do they all come up together?
Yes.
And how did it happen that one of the vehicles were uninsured? Or were they all uninsured?
So, Deputy, in the period of the uninsured vehicles, it was during COVID, we were taking on...
Were they all, was the whole fleet uninsured?
No. The
that's what I'm asking, yeah.
Sorry, the fleet was insured, but these were hire vehicles that came onto fleet for short periods and were missed in the insurance. 15 of them.
It was 15 vehicles in total. And it was, yeah, they just collected, they were just missed. Okay, I just wasn't sure. And for what length of time prior to the incident? How long were they uninsured?
Different lengths of time, it was over a period, but they were all insured by I think, the 15th of August.
Okay. So just what's the date there you used? 15th of August?
August, yeah, which was a few days after the accident.
Oh, it came to light once the accident occurred. Yeah.
I think it was a period from June, July until middle of August that there were some vehicles, and I think the vehicles were taken on at different times within that period.
Okay. And just the number of vehicles. How many vehicles have we got?
At the moment, we have 206, Deputy.
How many staff have you got?
We have an employee control framework number of 329, and we could have up to 400 staff between seasonals and contract staff at various times.
Yeah, because I thought I saw a number where there was the use of up to 400 vehicles. Is that correct?
Deputy, not really. While we might have had up to 400 vehicles available, they wouldn't be available 24/7. Our own fleet is available 24/7. The others are lease hires, and they might be available for a day, for 2 days, or for a week, or 6 months, depending on the purpose of them.
And was there any vehicles that we were in ownership of or paying leases of that we weren't using on a day-to-day basis?
No, Deputy.
That couldn't happen, no?
No, once they're unused, once they're not needed, they're returned.
Yeah, but even on a day-to-day basis, that they might be sitting in a shed for a couple of weeks.
Deputy, we monitor all our vehicles using a Transpoke or a telematics system.
Okay.
And if vehicles are identified as not moving, they would be flagged and dealt with.
Okay, and can you just tell me about the bounty system, because that's kind of confusing me with salmon. Because was there payments into bank accounts, and there was payments to staff? I don't know, there was payments to staff, there was payments to third parties. What was the situation there?
Deputy, this is a legacy issue going back to 1979 when the Union Institute...
When did it finish?
2024.
And where accounts were governed is?
Excuse me?
The accounts, the period we're governed is 2024.
We're looking at the 2024 accounts because it's a disclosure in our Statement of Internal Control.
Yeah, but can you just clarify what was happening there in 2024?
Nothing was actually happening in 2024, but in 2023 we got a protected disclosure which we investigated, and we discovered that some staff in had been receiving or claiming bounty for tags that they had gotten from salmon or from anglers.
What's a bounty for a tag? How does that work?
So it's a
Just
marine.
in layman's terms.
May I pass to my colleague here who knows more about the programme?
Yes, Deputy. So just to give you the context on it, the Marine Institute operated a bounty scheme for returned coated wire tags, which is a small microscopic tag that's inserted in the head of a juvenile salmon. The juvenile salmon then migrates out to sea, and when they return as adults, the tags are recovered, and it gives an estimation of marine survival. So this programme was going on for 47 years. There was a public bounty scheme where any angler or any person who recovered one of these tags could make a claim into the Marine Institute for the bounty. The bounty was €10.
And then where did the staff come into it?
We received, on foot of a protected disclosure, IFI undertook an investigation into this. I can speak to the detail of the investigation because it's now closed. We determined that the disclosure was upheld, that persons within the organisation had received payments, but we could find no evidence of wrongdoing.
Sorry, yeah, I know they were just in the course of their job.
No, this would have been done privately, and they would have made a claim privately between 2010 to 2023.
And was there, how much did any individual employee benefit?
We have identified two people that we can make a calculation on, Deputy, but the others involved, we can't get the information from the Marine Institute under GDPR.
Just for those, just so we know roughly, is it couple hundred euro, or what is it, the amount?
It averages out about €380 a year, roughly. But certainly between the two individuals we have, I'll ask Suzanne to give me the actual figure. It's around €8,000 over the period of time.
Okay.
Over a 14-year period.
I think it's important to recognise as well, though, between 2010 and 2014, I think, that IFI itself was receiving income under the bounty scheme, and then it ceased thereafter.
And you're saying they received it themselves?
They received it and recognised it as income of IFI, but then it ceased to be an income of IFI.
Who was paying it? Just from
Marine Institute.
Marine Institute were paying the IFI. Okay. And then that stopped?
And then it stopped in 2014, but it continued. There continued to be repayments or payments to individual staff or into accounts not controlled by IFI.
Thank you.
Thanks for that, Deputy Neville. Just a number of questions from myself. So just following our last engagement back in December, Mr. Collins, did the Minister write to you on foot of that engagement? And what was the thrust of that correspondence from the Minister?
I would say the Minister expressed a concern that I don't have the letter in front of me, but that the organisation would develop its transparency and its communication
Did
with
he
this committee.
express concern with the information or lack of information provided at the meeting?
I would say the Minister, I don't want to put words in his mouth, but I think he would have expected a fulsome engagement with the committee.
Okay. Well, you might furnish the committee with a copy of that letter, Mr. Collins. And did you bring that letter to the attention of the board on receipt of it?
Yes, I informed the board.
When did you inform the board?
I beg your pardon?
When did you inform the board?
Oh, I would say immediately at the first board meeting after receiving the letter, I would have informed the board that the Minister had written me, and of course I wrote back to the Minister.
Right. No, just there was a concern expressed that members of the board only found out about this letter from the Minister through the media. That was the first it was brought to their attention. Would that be accurate?
That they only found out about it through the media?
It was reported in the media, and board members, or certain board members, only found out about this letter subsequent to that media coverage.
Really, yeah.
I'm not aware of that.
That's news to me.
That's news to you?
Yeah.
Okay. Well, you might furnish us with a copy of that. I just want to go to the payment then to the former CEO, and at our previous engagement, I asked Mr. Fox about the decision to cut pay from full to half and then have it restored. He said he wasn't aware of it. He said it was a decision taken by the board. You had made reference to it earlier on, Mr. Collins, that this was, I suppose, a legal strategy or based on legal advice. So, so legal advice was given to cut it from full pay down to half pay. Is that correct?
There are situations where full pay within our policy system. If somebody is on, and again, I'm talking hypothetically here. If a staff member is on sick leave, they have 3 months full pay.
Okay, so you were given legal advice to go from full pay down to half pay.
We considered our policy suggested.
You considered your policy.
There
was no legal advice.
Legal advice supported it.
Okay.
We
why
made a
was the
policy
decision? Why was the decision then taken to restore it to full pay?
Essentially, to protect the institute, to protect the organisation.
And was that based on legal advice as well?
Absolutely.
So was the wrong legal advice given in the first instance? To reduce it down to half
we were happy with our policies. Our policies worked. We adhere to our policies.
Okay. Can I just ask, you made reference to agreement had been sought with the former CEO to come to some sort of a severance agreement. When did that take place, that engagement?
Yeah, that essentially took place towards the end of 2024 and into early 2025.
Okay. And at what stage could an agreement not be obtained?
It was, my guess is May of 2025.
May in 2025.
Yeah.
So the decision was then taken in June, shortly thereafter.
Correct.
Okay, and who led or who was aware of that process in terms of trying to come to an agreement?
The board were kept very closely involved at every stage of the process. And we had...
So were the board aware of the content of what was being discussed?
In broad terms, yeah.
In all terms of that agreement?
Yeah, absolutely. Yeah.
Okay. And anyone else I'm sure the Deputy CEO was fully across it? No?
Deputy CEO was not, nor indeed the Head of Finance, as we said earlier. The only staff member, we had 2 staff members who attended those special meetings. And again, it's with respect to the confidentiality of the employee who was then the CEO. The 2 staff members were the head of HR, who has since left the organisation.
Okay, so you and the board were fully across of every detail within that agreement. So just to move on, in December I asked Mr. Fox if he knew anything in relation to allegations of blackmail. Mr. Fox said he had no knowledge of any allegations of blackmail. Do you still stand over those?
Well, Deputy, I think now that we're in the process, WRC process, I can confirm I had reviewed communications. I have identified one communication that I received, but I'm not sure it's appropriate to speak about it.
Okay, so you gave incorrect information in December that you weren't aware of an allegation of blackmail?
It was a communication that was copied to me 6 months ago.
Okay.
And I've identified a line in quite a significant email that speaks to that.
Okay. So, Mr. Collins, were you aware of an allegation of blackmail?
I got the same email that you referred to, Chair.
Okay. Because it has been reported that the former CEO was allegedly being blackmailed to stop a fraud investigation in which he had initiated, and it's been cited publicly that that was by a serving senator. And there's also serious allegations there with regard to a former Taoiseach that he had put pressure on. Were they subject? Are you aware of those allegations, Mr. Collins?
Well, I sat through the WRC hearing, Deputy, and I really, as I said at the very outset.
Okay, so you only became aware of those at the WRC?
Well, in any, I mean, if you had said to me, did I ever receive an allegation from anybody in the organisation that anybody was being blackmailed in any kind of formal way?
So
Absolutely
you only
not.
became aware back in January at the WRC.
I became aware
can I ask,
formally.
were these issues raised through protected disclosures? Were any protected disclosures made to IFI citing concerns around these issues of political interference or allegations of blackmail?
I can say that such an investigation report never came to the board of IFI.
So there were no protected disclosures?
No, I'm not saying that.
Okay.
I'm saying I only see protected disclosures if I see them at all, once they've been investigated.
Okay.
I have never received on the board an investigation report.
Did the person that
states
deals with protected disclosures on the board, were protected disclosures along that nature made and received by that person that was dedicated to dealing with protected disclosures?
I would have no idea. This is what protected disclosures does.
Can I ask the department, were any protected disclosures made to the department highlighting these serious allegations?
As I mentioned to you at the beginning, Chair, and because we have still 4 live protected disclosures concerning IFI, unfortunately at this point I'm not at liberty to disclose the content of because we have some live protected disclosures still under investigation.
You have some live protected disclosures. So from that, I can take that these possible protected disclosures that were made are still live.
I can't confirm or deny, Deputy, unfortunately. So I can't go into any more detail either.
Okay, so can I go back to the agreement that had been sought with the former CEO? You said, Mr. Collins, you are fully aware and fully briefed of, I suppose, that legal strategy to come to an agreement with the former CEO. At any stage was the former CEO asked to withdraw protected disclosures that he had made?
Categorically no.
Categorically no. Okay. Can I ask as to whether a condition was attached at any stage as part of a proposed settlement agreement or severance agreement that protected disclosures would be withdrawn?
From memory, no. I will say this. Any discussion we had was towards full and final settlement.
From memory, no. I ask you to think that through. Give it the time, as your PR people said. Take the time, think it through thoroughly. Sure. So was there a condition attached in the proposed severance agreement put to the former CEO that he would withdraw protected disclosures?
I would say, Deputy, what was being presented to the Deputy, to the CEO who declined to sign, as I mentioned, was a proposal for a settlement which would be in full and final settlement.
Okay. So if I read from a document which I have seen that a condition had been proposed that the employee confirms that he knows of no facts which give rise to a protected disclosure in relation to the employer or to any current or former employee, officer or director of the employer in relation to the department, and that any protected disclosures raised by him in relation to such parties are hereby discharged.
In full and final settlement, the proposal is for full and final settlement. It never suggested to him that he was blocked from making any further disclosures after signing.
That is factual, what I read from
Yeah, fair enough. Okay. I'm not disputing that.
You're not disputing that. So I find that deeply concerning that in a settlement arrangement that was being put, IFI had as a condition in that protected disclosures would be withdrawn.
IFI chair had a condition that if this was signed, it was in full and final settlement. There would be no point in the organisation entering any
Therefore,
other
he would
relationship.
withdraw protected disclosures.
The organisation would not necessarily have been aware of what protected disclosures the CEO had or had not made.
Okay. Can I just get a view from the department? Were you aware of the content of what was being proposed or that had been put to the former CEO?
So, again, now I'm going to try and be a bit more helpful on this occasion, but firstly I must start by again stating that unfortunately there are live protected disclosures being investigated by the department. So I cannot speak to detail. However, I can speak more generally. As I explained to your colleague, the department operates under a set of rules if a severance arrangement is to be sanctioned. And one of the things that would need to be done is for the mediated agreement to be sanctioned in its own terms, in all its terms. We review the legality of the sanctioning of the agreement that is put before us. One of the things we would look to is to make sure that it is in breach of no law, that no rights that cannot be waived are waived. You know, it's that sort of aspect that we would look to. We wouldn't be in a position to sign off on a document that, for example, was in breach of the protected disclosure legislation. And we would address that in our communications with
So would you have signed off on the proposed severance agreement that we're discussing here? Would the department have signed off on that?
Yes, the department had a proposed severance agreement put to it and an arrangement and a business case made.
Which included the former CEO withdrawing a number of protected
As I've
disclosures.
said to you, Deputy, I can't go into the detail of this, but we approved what we understand to be the final version that was to be put to the CEO that ultimately he didn't accept. That was sanctioned not just by ourselves, but by the Department of Public Expenditure Reform, and it would have included legal review.
Okay.
And so it would not have included anything that did not pass muster from a legal perspective.
Okay. Well, I find it deeply concerning. Can I ask as to, was rationale given as to why that proposal was not accepted? Mr. Collins?
Not to me. I didn't. It was a matter for the CEO who declined it.
Would it be on the basis that they were not prepared to withdraw protected disclosures? Had that been given as rationale?
Well, I've never heard that.
You never heard that? That was not communicated back through your legal people to you, who had said your fingerprints were right across this process. Yeah. You were informed thoroughly and very up to date, you know, in relation to the minute detail of this. So your legal team, did they come back to you and give a rationale as to why this agreement was not being accepted? Again, I ask you to think that through thoroughly.
It is a matter for the client or for the entering a contract. One person or one party may decide to enter it or not enter it. We made an offer, and that offer was rejected, and that was as far as I regretted it was rejected, but it was rejected.
Okay. Well, just I'll conclude on this, and I will try to come back in a second round of supplementary questions, but I find it deeply concerning and very uncomfortable that as part of a settlement proposal that the withdrawal of protected disclosures would be included in that. And I'd question and I'd seek, you know, information from the department around the legal process around that, because I would question the legality of that, you know, forcing or including that as an agreement to withdraw protected the disclosures, given the seriousness of the allegations, as I see it, that were contained within those protected disclosures. So I'll open it back up with agreement with our witnesses that we open it up again to a shorter round of supplementary questions. Is that okay? Yeah, do our witnesses or anybody else need a short break before we proceed?
Just to say, Chair, I have to leave now, but just to put that on the record.
Okay.
Can I?
Yeah, we'll suspend the meeting for 5 minutes, if that's okay. And I call Deputy Boland again, so we have about 5 minutes.
In terms of the settlement agreement, as a standard in any employment matter, it was to be in full and final settlement. And that was the position. That's common practice in employment matters, that a settlement offer is based on it being in full and final settlement of all claims, except for those which cannot be contracted out of. And Secretary General, just to confirm that the IFI and the Department and DEPR would have taken advice on any settlement that would have been offered to the former CEO.
Well, I'm assuming the IFI did. I know they were legally advised. I know that it was reviewed by our internal legal team, and I recall that the letter of sanction that came back from PER actually expressly asked for an additional piece of transparency to be included in the final settlement agreement to ensure that it could be appropriately reported, including, for example, in the accounts of IFI.
Chair, just to confirm, the IFI did get legal advice on the settlement agreement before it was offered to the CEO. And so I suppose we've had 3 sets of legal eyes look at that settlement agreement, and they were all happy that it was in compliance with Irish law, that it could be offered.
Yeah. Well, certainly my legal team were satisfied that the wording of the severance agreement was appropriate, yes.
And obviously, as the CEO is entitled to do, he declined to agree to the settlement, and that is perfectly within his rights to do so. That's it. Thank you.
Thanks, Deputy Boland. Deputy Bennett.
No, thank you, Mayor. So I just want to go back to the piece on legislation. I'm a bit confused. So can you tell me again, how long has this legislative process been going on? What year did this start in?
So there's 2 separate pieces of legislation here, Deputy, which may be the cause of the confusion.
Okay.
So we have had for a very long time, as I understand it, I don't know how long, a proposal in hand that we would consolidate the fisheries legislation, which goes back to the 50s. Yep. However, on foot of the Blackwater fish kill, Minister Dooley, having listened to the concerns from the IFI and the report from the Commission about the inadequacies of the enforcement mechanisms, asked the officials to pull out the key parts of that legislation and update them first. And that is the proposal that we've started on with from late last year.
So the modernisation and consolidation legislation, did that ever go through?
No.
So that was ongoing from 2013. I have letters here that show 2013 it went out for public consultation, and that went on until 2000. What year did that go on? Maybe you can just...
The work, I'd say the work has been continuing on and off.
From 2013 to make one piece of legislation?
Well, it is a huge undertaking, as I understand it, because the Act covers so many different areas that require modernising and being brought up to the standard that we would expect today. The reason that it has been taking so long, which was the reason Minister Dooley wrote to the IFI after the fish kill incident and asked them to identify...
But why was it not in place before this? 2013, you're right, for public consultation. Why was it not done between 2013 and when Mr. Dooley comes?
It's a very large, complex piece of legislation.
How many years have you been working on it then? From 13 until...
It's a considerable amount of time. I don't have the exact number.
From 2013 until Minister Dooley come into place in 2024?
As the Secretary General indicated,
so
other priorities have usurped it at various points in that process.
But the reason why I'm saying this is because we have fines here of 277,000, was that correct? That we couldn't implement because there was no legislation in place.
I am not familiar with the figures you're referring to, but we have an ambition.
Okay, so whenever the fines, there was one of these documents, I have the fines. There was there were a lot of people going to be charged, but they couldn't be charged because there was no legislation in place, correct?
No, Deputy.
No, I have it here. I have it here.
So that's the delegations issue you're speaking to, the 61 cases we had to withdraw. That was due to a delegations issue internally in IFI.
Okay, the IFI can initiate prosecutions for serious fisheries environments such as fish kills and water pollution. Former delegated sanction from the board required for IFI officers to initiate prosecutions. In March 2023, a response to a legal challenge in the prosecution, IFI discovered a formal sanction of IFI staff was not in place. This discovery led to the IFI withdrawing 50 prosecution cases. Was them those 50 prosecution cases, were they not withdrew because there was no legislation in place?
No, Deputy.
It was because incorrect procedures were followed within IFI. The legislation, the fines were to take place on the basis of the current legislation, the outdated.
There was no legislation.
There is legislation.
Oh, so there was. So why were you out in 2013 trying to make legislation?
To consolidate and improve and simplify and bring the legislation into the modern era.
So then why could the fines not be implemented then?
It's a completely different problem as explained.
Can I maybe clarify that, Deputy? So under the 2010 Inland Fisheries Act, the functions of IFI are with the board of IFI.
Okay.
And those functions, whatever functions that they don't reserve for themselves, have to be delegated to the CEO, who in turn will delegate it to the specific head of function responsible for that area.
Yeah.
That process was not in place.
Why was that not in place?
Because the board did not delegate it down to the chief executive at the time. And
Why would that happen?
We find it hard to explain ourselves.
Can the department maybe answer me that, why that didn't happen?
No, it's an internal process to IFI.
It's an IFI issue.
But are you not there for oversight?
But we're not there sitting alongside them day by day, Deputy. We have governance arrangements, but this was an internal oversight by IFI, discovered by IFI.
Yeah, but as a department, do you not have a role in the IFI? If the IFI is not carrying out their governance, do you not have a role there?
Yes, but it was usually reported to us through the governance arrangements,
so
but it was an issue
So when it was
from
reported
IFI.
to you, what did you do?
Well, at that point, the matter had been resolved by the IFI, Deputy.
It wasn't resolved because lots of the offences were withdrew. 50 prosecution cases.
Yes, but they had that point. Yes, and that was under legal, as I understand, it was under legal advice. I don't want to speak for the IFI, but at that point they had put the delegated sanction in place, so prosecutions could lawfully take place thereafter.
Okay. And what has happened since in relation to that the 50 cases were withdrew? Is there any procedures put in place now that this will not happen again?
Yes, Deputy. So we now have a scheme of delegations in place which tracks all our delegations. So the delegations to the executive are, we can confirm they are all in place. They are checked on an annual basis. The board are review the scheme of delegations at their meetings, and we don't believe that this can happen again.
Okay, and what was the total loss at that stage and the legal costs?
The total cost is 271 at the moment, Deputy. There's still 5 cases outstanding.
277.
Sorry, 277.
Yeah.
There's still 5 cases outstanding. They're for finalisation, so there will be additional costs.
Okay, and would the department have been, you were notified that there was 277,000?
Yes, Deputy, it was, it was recorded, obviously it was recorded by the CNAG, notified in their accounts, and would have been obviously something that came up during our quarterly corporate governance meetings and so forth.
Okay, just a quick question if I can, Chair. In relation to the management of Ashley Lodge and cottages, can you tell me where that is at now? Is everything in place?
Deputy, the cottages have recently received planning permission and the folio has been split. The properties are uploaded onto the OPW as is protocol, and once the time limit has passed, we will be able to approve or go to the board for approval, which will then go on to the department, which will then go on to DEPR for approval to sell and retain the funds.
So at the moment, Ashley Lodge and cottages are still sitting with?
Well, the cottages are sitting, I suppose you could say, because we've been...
What's the value of those cottages?
Deputy, I'd prefer not to say because they're going to be on the market.
Yeah. How many cottages is there?
It's one building, but it's split in 2.
It's split in one building. And then there's also the lodge as well, is it?
The lodge is there. The lodge is
So they're both up for sale?
No, the lodge is not up for sale.
And what's happening with the lodge?
The lodge is being developed as a training and research centre, and it's being used, for training.
That training and research centre, who's rolling that out?
We are.
The IFI, okay.
Yes.
How much is that costing?
Well, it's costing very little at the moment because we're using what we have and seeing what way we can adapt it to make the best use of it.
Okay. Okay. So they're both of the lodge and cottage are currently vacant.
The lodge is being used.
The lodge is being used.
Yes.
For training.
For training, yeah, and meetings.
I didn't think it was actually happening yet.
No, it actually saved us 13,000 last year by using it.
Yes. Using it for the training.
For training.
Okay.
Yeah.
All right. No, I think that's all my questions. Thank you.
Okay, thanks for that, Deputy Bennett. Just some concluding questions from myself. I just want to return to a line of questioning that I had previously been following, and that was the protected disclosures, the serious allegations of blackmail that had been made. So can I ask as to whether the board is aware of those allegations in which Mr. Fox said he was made aware of 6 months ago, and Mr. Collins said he was aware of? Had they been referred to the Gardaí by IFI?
Deputy, for me, formal complaint on blackmail was never received, has never been received. So clearly, in the absence of any complaint of that nature, we're not going to refer it.
Can I ask the department?
Regrettably, Chair, the matter is the subject, there are live investigations of protected disclosures underway in the department, and I'm afraid I can't go into any detail.
Okay, is the department aware of any criminal investigation with regards to the content of some of those protected disclosures?
I certainly am not. So I would think not.
There's a live investigation in process with an independent investigator, so those matters will be the subject of that. So I wouldn't be reluctant.
An investigator from.
Sorry, I should say the department's never been contacted by An Garda Síochána saying they are investigating allegations of blackmail.
Okay.
Okay. Maybe that's the best way to
And the investigation you were talking about there, Mr. Martin,
is the one I'm referring to.
is the one you're referring
It's
to.
in progress.
Okay. So we're not aware of any investigation by the Gardaí at the moment. Okay. And just again, in relation to that particular clause in that settlement, which was rejected, again, I feel very uncomfortable, and I would ask the department to give sight of the legal advice that was given for the inclusion of, that provision that protected disclosures would be dropped, because as far as I can ascertain, that there is certainly no provision there, certainly within the protected disclosure legislation, to give, merit to a position or an approach like that.
Again, Chair, unfortunately, we have live investigations underway into protected disclosures in the department, and I will regretfully not be able to give any comfort to you on that. And I would also suspect that our legal advice probably would be something we would hesitate to make available. What I can say, as I have assured you, is that department officials don't sign off on agreements that would be in breach of laws.
Okay. I just want to move on in relation to the appointment of deputy CEOs, and we know Ms. Campion was deputy CEO at one point. How long did you hold that position for, Ms. Campion?
Just over 6 months, Deputy.
6 months. And Mr. Fox, how long are you currently in the position?
I was in a period for 6 months, and I was reappointed in September of last year.
Reappointed in September of last year, and reappointed by
the board.
By the board. And at a previous engagement, you said that there was provision within the legislation for the appointment of deputy CEOs. What section of the legislation provides for that?
Section 24(1), if my memory serves me right, Deputy. I'll remain to be.
It's 2010.
2010, sorry.
2010. That makes reference to a temporary, or does it define durations or anything like that? for the Deputy CEO?
No, it doesn't, through the chair.
And in both of those positions, were the positions advertised internally, externally, Mr. Fox? Or the board?
The board handled it, Deputy.
Were they advertised
They
internally?
were. Not the rotating one, because that was a 3-month arrangement or a 6-month arrangement. But when we came to stabilise the arrangement, that was advertised for people at the level of PO in the organisation.
Was that September last year? Or at what stage was it advertised?
That was last August, I think, of 2025.
But prior to that, there was no, the positions weren't advertised internally or externally?
No, there was an internal procedure in place.
An internal procedure, but they weren't advertised. Okay. Can I ask the department in terms of, you know, for me, a deputy CEO is over a very short period of time, certainly not for an extended period of time, which you've seen within the IFI. Is this something that was given approval by the department?
Obviously, we've mentioned, Chair, how long the organisation has been without a CEO. So it is important that the organisation can run as somebody with the authority to take decisions about things like staffing and budgets and so forth. So yes, the department would have been aware of the way in which the IFI was seeking to manage the vacancy at the very top of the organisation.
And the department had given approval?
I don't have that. I presume we did, but we'll have to check with you as to whether there was written sanction or how that went.
There were no concerns expressed by the department in terms of the process or the length of time in which the deputy roles had gone on for?
I am not aware of any such concerns being expressed, but we can check that, Deputy. Chair, sorry.
Yeah, if you could check that. I welcome the appointment of the new CEO, and I look forward to, I'm sure, engaging with Mr. Kelly at some point in the future.
Hopefully the distant future.
We'll see. Can I ask as to whether anyone here went for the position? Mr. Fox, did you go for the position of CEO?
A private matter for myself, Deputy.
A private matter for yourself. Ms. Campion, did you? Private matter for yourself. Can I ask as to whether Mr. Kelly was the unanimous candidate put forward by the board to the department?
I think
it was a public jobs appointment.
The process was managed by the PAS. The board, I was on the interview panel. There was one other member of the board on the interview panel. But the process was managed by the public appointment system. So they came forward with the nominee to us. It came from the board, approved that unanimously, and the board then sought the approval of the minister.
Yeah. Okay. I just want to move on to the issue of, I suppose, the process of bringing people through the courts and the failure and the amount of cases that were ultimately dropped and the costs incurred by that failed process by IFI. And can I ask, just in relation to a strategy pursued by IFI in relation to a court case involving 3 persons in Donegal, a local angling clubs there who are dragged through the courts at great costs, has to be said. I'm sure you're aware of the case I make reference to. It's in relation to the Guibara River in Donegal fishing rights there. Are you aware of that particular case, Mr. Collins?
No.
Mr. Fox?
Predates me.
I'm aware of it, Deputy, but it's certainly outside the scope of this meeting.
Well, it's not outside the scope because it involves, as had been highlighted in our previous engagement, the strategy of bringing people through the courts. And when there was no legal basis, we know that the authority had not been handed over to IFI to proceed on those cases, so there was no legal grounds. Hence, at great cost, those cases had been dropped. So I'm trying to establish as to whether there was a legal basis in terms of the rights and the strategy pursued by IFI in relation to court cases of that nature.
Can I just clarify, we're talking about a historical case here, not a current case that went through the courts, Deputy, am I right?
It's a historic case that has been through the courts.
Yeah. So I don't have the paperwork in front of me. What I can confirm is that IFI were awarded the costs in that case, which were significant against the individuals. We have elected not to proceed with pursuing those costs. But the case was, we were fully entitled to pursue that case.
Okay, fully entitled. So are you totally satisfied that there was a legal basis then to pursue that case?
There was a legal basis to pursue it, but I wouldn't have been involved in the deputy gut.
Okay,
The organisation.
so the issue then of fishing rights within the Guibara
is
River,
resolved.
That is resolved.
Yes.
And who holds those fishing rights then?
IFI.
Yes. Okay. That concludes my line of questioning.
Can I clarify one thing, Deputy,
Yep.
with you? Just for the record, I did locate during the break the letter from the Minister that you referred to in your opening questions. So it was dated the 16th of December of 2025. And the minutes of the board meeting happened to happen on the 17th of December, 2025. And it is minuted that I read the letter into the minutes of the board.
Okay, that's fine. We have a copy of that letter there, so I acknowledge that, and I'll be sure that that's circulated to all members of
Thank you very
the
much,
committee. So thank you for that. So that concludes our engagement for today. I would like to thank the Chair and his officials from Inland Fisheries Ireland for attending today. I would also like to thank the officials from the Department of Climate, Energy and the Environment and the CNAG in his absence for their attendance once again. So is it agreed that the clerk will seek any follow-up information and carry out any agreed actions arising from the meeting? Agreed. The committee will next meet again on Thursday, the 16th of April 2026 with the Department of Education and Youth to resume discussions on the Appropriation Account 2024, Vote 26, the Appropriation Account 2024, the report on the accounts of the Public Services 2023 and Chapter 7 protecting the state's investment in the schools estate. So the meeting now stands adjourned.